of such order, item number 1.
For reasons mentioned in the order, the petitioner is allowed to go on bail of rupees 50,000 with two sureties of like amount with certain conditions mentioned in the order.
Item number 3.
In bail application number 790 also, the petitioners are allowed to go on bail of rupees 50,000 with two sureties of like amount with certain conditions. In item number 3, also, Abdul Razak and two others, they are allowed to go on bail of rupees 50,000 with two sureties of like amount with certain conditions mentioned in the order.
Item number 4.
For reasons mentioned in the order, the petitioners Rashid Ahmed is allowed to go on bail of rupees 50,000 with two sureties of like amount with the conditions mentioned in the order.
Item number 5.
For reasons mentioned in the order, the prayer for bail is rejected at this stage. Yes.
Bless your Lordship. Lordship, I'd like to mention item 30.
30.
Item 30, item 33. And item 64, Your Lordship.
They are similar matters. No.
No. I'm representing the state here.
But petitioners are different.
Petitioners are taken to consent, Your Lordship.
You have taken consent. Let us go one by one. In item 33, what is your prayer? In item number 30, yes, Mr. Imchen. Item number 30.
Your Lordship, I have no objection.
He has not made the prayer. What are you mentioning for? Are you seeking adjournment?
Yes.
You have to mention it. Adjournment,
Yeah, the explanation.
you have to say for what reasons, for how long you are seeking adjournment.
Lordship, let this come up after 2 weeks.
Okay. Heard Mr. Moa Imchen, learned senior government counsel, who prays for an adjournment for 2 weeks. Learned Mr. Tongpok Komener, learned counsel for the petitioner, does not object to the said prayer, hence the prayer is allowed. Let the matter be listed after 2 weeks. Then item number 33.
Yes, Your Lordship. This, I have to obtain instructions, Your Lordship.
Heard Mr. Moa Imchen, learned senior government counsel, who prays for an adjournment of 2 weeks on the ground that he has to seek
Lordship, 3 weeks time.
3 weeks on the ground that he has to seek necessary instructions.
Lordship, there's an interim.
Ms. Losino,
Lordship.
learned counsel for the petitioner, does not object to the said prayer, hence prayer is allowed. Let this matter be listed after 3 weeks. The interim order shall continue till next date.
Much obliged.
In item number 64. Yes, Mr. Imchen, last item is?
Yes, last item is hearing, Your Lordship. Let this become up tomorrow, Your Lordship. Pass over for the day.
No, let it come up
It is forwarded.
after a week.
Tomorrow.
Which item is that, my lord?
64, item number 64.
6-4, yes.
6-4.
Last item, hearing.
Heard Mr. Moim Chin, learned senior government counsel, who prays for listing this matter tomorrow, that is on 4th of August 2023. Ms. Asangla Waling, learned counsel for the petitioner, does not object to the said prayer. Hence, let this matter be listed tomorrow.
Okay.
Next, Lordship. Lordship, I beg to mention item number 38, Lordship. For the appellant. Lordship, here I'm led by Mr. Tangchuba. He's in bereavement, so that will come up after 2 weeks, Lordship. Item 38.
Item number 38.
38.
Heard Mr. Foseco Forte, learned counsel for the appellant, who prays for an adjournment on the ground that the leading counsel for the appellant, Mr. Taeyong Chuba, is in bereavement. You have
Yes,
informed
considering the consent of the counsels.
learned counsel for the petition. Appellant also submits that he has already taken consent of the respondent side. Hence, the prayer is allowed. Let this matter be listed after
2 weeks, Lordship.
2 weeks.
Bless my lord.
Yeah, please, Your Lordship. I have pleased to mention hearing item number 41, 42, Your Lordship. Your Lordship, let the matter come up next Tuesday, Your Lordship.
Lordship, may this be the last chance, no further adjournment, Lordship.
Okay. Heard Ms. Livika, learned government counsel, who prays for listing this matter on
Next Thursday.
next Thursday, that is 10th of August 2023. Mr.
Luckily from Lordship.
Write his name. So, learned counsel for the petitioner submits that this may be for the last time the this may be regarded as the last time for which the prayer for adjournment is granted to the petitioner. Considering the submissions of the learned counsel for the both sides, the prayer is allowed. Let this matter be fixed on 10th of August 2023.
Bless, Lordship.
May I also please to mention item number 50 to 53, Your Lordship. 50 to 53. Lordship, let the matter come up next week, Your Lordship.
Lordship, otherwise I'm ready for the hearing.
But what is your submission on her prayer for adjournment? Why are you praying for
Your
adjournment?
Lordship, I'm not feeling well, Your Lordship, that's why.
Okay. Heard Miss Livika, learned government counsel, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. I. Epok Pongener, learned counsel for the petitioner. You are not objecting.
Lordship, if my learned friend is not feeling
Who is
well,
not objecting to the prayer, considering the ground mentioned by the learned government advocate. Hence, the prayer is allowed. Let this matter be listed after a week.
Next week, Your Lordship.
After a week.
Much obliged.
Please, Your Lordship. Lordship, I'd like to mention item number 29, Lordship. Lordship, here the pleadings are complete, Lordship. So if this matter can come up on the 22nd of August for admission hearing, Lordship. I've taken the consent of the 29.
Let it come, if pleadings are complete, let it come up for hearing, for admission hearing.
For admission hearing, Lordship.
Heard Ms. Lucino, learned counsel for the petitioner. Also heard Mr. John P. Izum, learned counsel for the respondent. It is submitted at bar that pleadings in this case is complete and matter may come up for admission hearing on
22nd of August, Lordship.
22nd of August.
Lordship. And in the meantime, if the interim may be extended, Lordship.
Interim is there,
Lordship.
and considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed on 22nd of August. The interim order shall continue till next day.
Obliged, Lordship. Yeah, please look at it. Your Lordship, I beg to mention item 27. Your Lordship, since the leading counsel is out of station, if the matter be fixed on 8th of this month.
Yes, what's your name? Miss Conley
Yes, Your Lordship.
Buchem, learned counsel for the petitioner, prays for an adjournment on the ground that Mr. Santi Younger, learned counsel for the petitioner, is out of station. Learned Mr. KV Angami, learned government counsel, representing
No objection, Lordship.
the respondents as well as
I'm for respondent number 4, Lordship.
Mr.
Luckney form, Lordship.
Lakney form, learned counsel appearing for respondent number 5, does not object to the said prayer. Hence, let this matter be listed on 8th of August 2023.
Your Lordship, I have similar prayer in item 39 as well. Your Lordship, there is an interim in the previous.
The interim order shall continue till next date in earlier. In item 39 also, same order, but instead of 8th,
Yes, Your Lordship, 8.
item 39 also you are praying for 8th,
Yes, Your Lordship.
same order.
Much obliged.
Please, Your Lordship. Lordship, I beg to mention for admission item 23 and 24, Your Lordship. I have taken the consent of the opposite party, Your Lordship. May I pray this matter be listed after a week?
Heard Miss
S. Mary, Your Lordship, for the state.
S. Mary,
Yes, Your Lordship.
learned senior government advocate, who prays for an adjournment for a
week, Your Lordship.
for a week. Also heard Miss Lima Naro, who does not object to the said prayer. Hence the prayer is allowed. Let this matter be listed after a week.
Lordship, I would also like to mention item 47 and 59, Your Lordship. Your Lordship, after 3 weeks, Your Lordship. I've taken the consent. 47, Your Lordship. 47 and 59, Your Lordship.
Item number 47, heard Miss S. Mary Leonard, Senior Government Counsel, who prays for an adjournment for a week with the consent of the, she has taken the consent of the Learned Counsel for the petitioner. Hence the prayer is allowed. Let this matter be listed
3
after
weeks. 3 weeks, Your
3 weeks. 47 and 59.
Yes, Your Lordship. 47, 59. I'm okay.
Mr. Longchar, you don't have objection. In 59 also same order.
May I please, Lordship? I beg to mention hearing item number 48. Kindly list it out after 3 weeks.
Why are you praying for adjournment?
My senior has some personal difficulties
Okay.
on behalf of Sir Motin.
Heard Mr. Manek Konyak, Learned Counsel for the petitioner, who prays for an adjournment due to personal difficulties of his senior, Mr. Moaz Zamir. Considering the submissions made by Learned Counsel, the prayer is allowed. Let this matter be listed after
3 weeks.
3 weeks.
Lordship, I also beg to mention item number 43, 44, and 45 on behalf of leading counsel P. Barwa. Lordship, kindly refix it on 14th of August for admission hearing.
Why
He's out of station.
heard Mr. Mane Konyak, learned counsel for the petitioner who is submitting on behalf of Mr. P. Burwa, learned engaged counsel for the petitioner, and prays for an adjournment, and also prays for fixing this matter on 14th of August.
Lordship, there's also an interim.
Stop. Who is for the government side? Consider
For government, it's Sir Mohammed. I've taken his consent.
learned counsel for the petitioner submits that he has obtained consent of the state learned counsel for the state respondent. Hence, the prayer is allowed. Let this matter be fixed on 14th of August. The interim order shall continue till next date.
Please, Your Lordship, I beg to mention item number 32. Your Lordship, here I have instructions to appear for private respondent number 5. Number 4. So, Your Lordship, kindly allow me 3 weeks' time to file my counter.
Heard Miss V. There, who submits that she has instructions for appearing on behalf of private respondent number 5 and
4, Your Lordship.
private respondent number 4, and prays for 3 weeks' time to file counter affidavit. Also heard Miss T. K. Sukru, learned counsel for the petitioner who does not object to the said prayer. Hence, let the matter be listed after 3 weeks.
So bless you, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention hearing item number 37, Lordship. Lordship, if this matter can be listed next week, Lordship.
Heard Miss
Mika, Lordship.
Mika H.I., learned counsel for the petitioner, who prays for listing this matter next week. Mr.
I am Chen, Your Lordship.
I.
Respondent number 1.
I. Im Chen, learned counsel for the respondent number 1, does not oppose the said prayer. Hence, the prayer is allowed. Let this matter be listed after a week.
Lordship, bless you.
May I please, Your Lordship? Your Lordship, I beg to mention item number 28. Your Lordship, here pleadings are completed, so let the matter come up for admission hearing after 3 weeks.
Heard Miss A. Aimi, learned government counsel. Also heard Mr. I.M.T. Longchair, learned counsel for the petitioner. It is submitted at bar that pleadings in this case are complete and the matter may be fixed for admission hearing
After 3 weeks, Your Lordship.
after 3 weeks. Considering the submissions made by learned counsel for the parties, let this matter be listed
For admission hearing.
for admission hearing after 3 weeks.
Much of
Much obliged, Your Lordship. Your Lordship, item number 34 on behalf of additional AG. Kindly let the matter come up after 1 week, Your Lordship.
May I please, Lordship, I'm for the petitioner. Lordship, the matter is very simple. The prayer in this writ petition is just a simple direction to the Chief Secretary.
Why are you praying for adjournment?
Your Lordship is indisposed today. So it's just a matter of 1 week, Your Lordship.
Otherwise, Lordship, as I said, prayer is very simple.
No,
And
heard Miss A.I.M.E., learned counsel for the state respondent who is submitting on behalf of additional AG, Mr.
Imti Imsong,
Im Ting Song, and prays for an adjournment
1 week.
of 1 week on the ground that Mr. Im Song is indisposed. Mr. A. Zo does not object to the said prayer. Let the matter be listed after a week.
Major.
Your Lordship, similar prayer for item number 40 on behalf of additional AG Imti Imsen. Let it come up after 1 week.
Lordship,
40 same orders instead of Mr. Zo, earlier order, same order, instead of Mr. Zo, mention the name of Mika, A-H-I, after
1 week, Your
1
Lordship.
week.
Much obliged.
That is a Lordship. Lordship, I would like to mention item number 67, Lordship, supplementary list, Lordship. Lordship, here you have to receive the CD, Lordship. So if Lordship may please to grant another 1 week time, Lordship.
Okay, Your Lordship.
Howard Mr. V. Zimomi, learned,
Vijmomi.
V. Zimomi, learned, V.
V for Ben.
Mr. V. Zimomi, learned, Public Prosecutor Nagaland, who submits that he is yet to receive the case diary which was called for in connection with this case, and prays for 1 week time to produce the case diary.
Lordship.
Your Lordship, if it will be fixed on the 10th, Your Lordship. 10th of August.
Also heard Mr. Z. Kunnu, who does not object to the said prayer.
Yes.
Hence the prayer is allowed. Let this matter be fixed on 10th
Lord.
of August for case diary.
I love that.
May I please, Your Lordship? My Lord, I beg to mention item number 25 on behalf of Sobung Lachang, my Lord. She is not feeling well, so let the matter be taken up after 2 weeks, man. Item number 25.
Who is for the petitioner? You have
I have no objection.
heard Mr. T. E. Tibafom, who submits that learned Government Counsel Ms. Supungla Chang
Yes,
is indisposed
yes.
and prays for an adjournment on that ground. Mr. Manye Konyak, learned counsel for the petitioner, does not object to the said prayer. Hence the prayer is allowed. Let this matter be listed after
2 weeks, man.
after 2 weeks.
My Lord, again, I beg to mention item number 54, heading 54, on behalf of Ina Holy, my Lord. Let the matter be taken up after 2 weeks, my Lord.
On behalf of
Ina Holy, my Lord.
heard item number 54, same order, change the name of the counsel who is Mr. E. Tibafom submitting on behalf of Ina Holly on the ground of
Government Council.
Government Council, prays for an adjournment for 2 weeks.
Yes,
Mr. Longchar, IMT Longchar does not object to the said prayer, hence the prayer is allowed. Let this matter be listed after 2 weeks.
Much obliged. And my Lord, I beg to mention item number 55, hearing number, on behalf of Sobungla, my Lord. Let the matter be taken up after 3 weeks, man.
Same order, submitting on behalf of Supongla Chang after 3 weeks.
Much obliged.
May it please Lordship, my Lord, I beg to mention item number 26 on behalf of the petitioner. And also on behalf of the respondent number 2, as the counsel who is supposed to appear, she could not come.
What is your prayer?
My Lord, as consented by the parties, let this matter come up on 7th of September as a fixed matter for final hearing.
7th of September,
7th of September.
heard Mr.
B. Soto.
B. Solo, learned counsel for the petitioner, who prays for an adjournment and fixing this matter on 7th of September on the ground of personal difficulties of the learned counsel for the petitioner. Also heard Mr. K.V. Angami, learned senior government counsel, who does not object to the said prayer. Hence, the prayer is allowed. Let this matter be fixed. For what? Admission hearing.
Admission hearing, my lord.
For admission hearing on 7th of September.
And my lord, there is an interim.
The interim order shall continue till next date.
Much better.
May I please, Lordship? I may be allowed to mention item number 22, my lord. My lord, I've read that this matter may be listed up to 3 weeks, my lord.
Ground,
My lord,
Mr. Long Kumar.
and Mukuma, my lord.
And you are for?
I'm for the respondents.
Who is for the petitioner? Heard Mr. N. Long Kumar, learned counsel for the respondent, who prays for an adjournment for 3 weeks. Learned counsel for the petitioner does not object to the said prayer, hence the prayer is allowed. Let this matter be listed after 3 weeks.
Obliged, much obliged.
May it please your Lordship. Lordship, I beg to mention item 62. Lordship, my senior, Mr. Yang Gauhati CJC is indisposed, so kindly list this matter after 3 weeks, Lordship.
62 heard Ms. Desino Kiso,
Yes, Lordship.
who submits that her senior, Mr. Mr. Yangarwati, learned Central Government Standing Council, is indisposed and prays for an adjournment for 3 weeks on that ground. Mr. Imti Langchar, learned counsel for the petitioner, does not object to the said prayer. Hence, the prayer is allowed. Let this matter be listed after 3 weeks.
Much.
For motion, item number 1.
Please, Your Lordship. Your Lordship, here the petitioner is approaching this honorable court for releasing of the ceased vehicle in connection to Chart 373/2023. This police station Timoko. Your Lordship, here on 4/6/2023, one person, namely AP Saikuchi, has filed a complaint. So, based on the complaint, one person, alleged accused person, was arrested along with the seized vehicle. Your Lordship, may kindly see my annexure 1, page 10, Your Lordship. 10A. For more clarity, I've put the NXT that copy, Your Lordship.
Yes.
This is the FR, Your Lordship, which was filed on 4/6/2023, Your Lordship. We have allowed to read, Your Lordship. Also, at around same telephonic information was received from control room Timoko about the vehicular accident occurred near New Senatorial House. Accordingly, self along with the duty party rushed to the PO. After reaching the spot, it was ascertained that one pedestrian, unidentified, age around 50, non-local, was hit by one elbow, bearing number so-and-so, traveling by same on, age 21, son of so-and-so. However, the injured person was immediately taken to Olive Hospital for medical treatment by the auto driver, but he was declared drop dead. Later, after observing all the legal formalities at Olive Hospital, the dead body was shifted to the district hospital Timoko. Now, Your Lordship, this is the FR. So, based on the FR, the alleged accused person was arrested along with the seized vehicle. Now, Your Lordship, here the prefix of the case is that on the platform day, that is on 4/6/2023, the accused person had approached the applicant, who is the owner of the vehicle, for purchasing the said vehicle. Now, Your Lordship, in consideration of that, the accused person had paid an amount of rupees 1 lakh as in advance, and the remaining to be paid within a week. Now, Your Lordship, in the meantime, later in the evening, the applicant, the owner of the vehicle, had come to learn that his vehicle has been involved in the incident. Therefore, the applicant, the owner, had approached the families of the accused person, and they have compromised among themselves to revoke the sale. Now,
Revoke the sale.
yes, yes. Accordingly, they have also executed the sale date, Your Lordship. Your Lordship may kindly see my annexure 2 at page 11, Your
No,
Lordship.
who is the present petitioner? Present petitioner is not the accused.
Yes,
He
yes,
is the
Your
owner.
Lordship.
He is the owner of the vehicle.
Yes, 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 Your Lordship.
Okay.
So, Your Lordship, may kindly see my annexure 2 at page 11. This is the declaration they have made among the applicant and the accused person in order to revoke the sale which they have made, Your Lordship. Now, Your Lordship, may kindly see my annexure 3 at page 12. These are the registration certificate which is in the name of the petitioner, Your Lordship. Is Your Lordship, may kindly see my annexure page 13. This is the NOC which was issued against the petitioner, Your Lordship. Now, Your Lordship, after the schedule has been met, the applicant had approached for the Learned Chemistry Court, Dimapur. Your Lordship, may kindly see my annexure 4 at page 14.
Yes. Yes.
Annexure 4 at page 14, Your Lordship. The applicant had filed before the Learned Chemistry Court, Dimapur, Your Lordship. However, it was rejected on the ground stating that Your Lordship, may kindly see my page 15. I may be allowed to read the relevant part, Your Lordship.
Yes. Yes.
Yes. Considering the above facts and circumstances, while the primary object of the provision of interim custody is to ensure that the owner of the article would not suffer because of its remaining unused or by misappropriation, yet, however, then the ownership has not been established, the release of property would defeat the object. Accordingly, the prayer of the petition is rejected, Your Lordship. This is the rejection order which was by the Learned Court below, Your Lordship. Hence, the petitioner is approaching this honorable court, Your Lordship.
Yes, Mr. Zimomi.
May I please, Lordship? Lordship, at this stage, Lordship, I am allowed to produce the status report.
His diary would be required. Or
Lordship.
no. Whether vehicle is required for the investigation.
Lordship, that I need to seek a status report, Lordship, so that I can ascertain, Lordship. Until and unless I receive the instruction, I can.
Heard Mr. Toshi Temjen Pominer, Learned Counsel for the petitioner. Also heard Mr. V. Zimomi, Learned Public Prosecutor. This instant application under Section 482, read with Section 451 of the Code of Criminal Procedure, 1973, has been filed by the present petitioner, who claims to be the owner of vehicle bearing registration number. Yes, where is the registration number? What is the registration number of your vehicle? Registration number AS1212 AS12J AS1 to J 2489, which is the subject matter of the GR case number 373/23 corresponding to East PS case number 143/2023 under section 279/304A of the Indian Penal Code, read with section 181/183 within bracket 1/184 of the MV Act, which was registered on the basis of an FIR lodged by one Toshi Iyer, ABSI of Traffic Control Dimapur. Stop. Learned public prosecutor submits that he may be allowed to seek instruction, take necessary instructions from the investigating officer of the East PS case number 144/2023 as to whether retention of the seized vehicle is necessary for fair investigation of the said case or not. Hence, the prayer is allowed. And then, hence, before that, before submission, issue notice to the respondents as Mr. V. Zumumi receives notice on behalf of the sole respondent. No fresh notices need to be issued. Thereafter, the submission. Thereafter, call for a status report from the investigating officer of East PS case number 144/2023, clearly stating as to whether retention of the seized vehicle bearing registration number AS1 to Z 2489 is necessary for fair investigation of the said case or not. Let this case be again fixed on after a week for the status report.
For motion, item number 2.
Yes.
May I please, Lordship. My Lord, this instant IA is filed for extension of period, my Lord. My Lord, here by order dated 17/4/2023, passed in WBC number 120 of 2022, direction has been given to the state respondent to consider the petitioner case within 3 months, my Lord. However, my Lord, despite within the specific period, the state government could not complete the process, my Lord. So we need another 3 months, my Lord. The matter is already forwarded before the cabinet for everybody.
Yes, Your Lordship. As far as the time period is concerned, I don't have any objection, Your Lordship. But for the complaints of this earlier honorable court dated 17/4/2023, Your Lordship, as per the index here, they have included in the IA, Your Lordship, at page 9, Your Lordship. It is seen that the names of the petitioner along with the others were forwarded in the year 2019, Your Lordship. So, at this stage,
At page 9.
Page 9, Your Lordship. This is later written by the Additional Chief Engineer Office of the Chief Engineer PhD Nagaland Kohima to the Principal Secretary to the Government of Nagaland, that is on 3rd October 2010, Your Lordship, 2019, Your Lordship. So, my only submission is that if a clear direction will be given to the state respondents to comply with this earlier and honorable court order dated expeditiously for regulating the service of the petitioner as per the OM, Your Lordship. That's my only submission.
No, that order has already been issued earlier to consider your representation within 3 months. What was the earlier order for which the extension is sought for? Which order you are seeking extension?
My lord, order dated 17/4/2023, Annexure A, my lord,
At page
page number 6. Your Lordship, may kindly see Annexure B, page number 8. Here, it's clearly mentioned that the matter is already forwarded before the cabinet approval, my lord. On 12/6/2023.
now you are seeking 3 months more.
Yes, my lord.
No, they are seeking only 3 months more.
Yes, Lordship.
You have any objection
No,
or any
Lordship.
submission?
No, Lordship. Just a simple, just a one submission that if the state respondents may take the steps for regularizing the service of the petitioner
They are-
within the 3
they
months
are-
expeditiously, that's only, Lordship.
Okay, so you are not objecting?
Yes, Lordship.
Heard Mr. E. Tibafom, learned counsel for the petitioner. Also heard Mr.
Supongwati. Supongwati. Wati.
Supangwati, learned counsel for the respondent. This instant interlocutory application has been filed by the petitioners seeking extension of period for compliance of order, seeking extension of 3 months more time for compliance of the order dated 7/4/2023 passed in WPC number 120/2022, wherein the state respondents were directed to take necessary steps for regularization of petitioner as per office memorandum dated 17/3/2015 within the period of 3 months. Learned Mr. E. Tibafom, learned government counsel,
Yes, my lord.
submits that in pursuant to the said order, the respondents have already taken steps and the matter is pending for cabinet approval.
Yes, my lord.
And in support of his contention, he has produced a letter dated 12 June 2023 by Deputy Secretary to the Government of Nagaland. On perusal of which it appears that the government has submitted 30 sets of cabinet memorandum in respect of 92 posts of various work charged employees under Public Health Engineering Department for consideration of the cabinet. It is submitted by learned counsel for the petitioner that the case of respondent is also within those 92 matters which are placed before the cabinet. Mr. Supamwati, learned counsel for the respondent, does not oppose to the said pair. However, he submits that government may be directed to expeditiously consider the regularization of the present petitioner in terms of the order passed earlier on 17/4/2023. Stop. Considering the submissions made by learned counsel for the petitioner. This interlocutory application is disposed of with an observation that another 3 months time is granted to the respondent. Another 3 months from the date of this order is granted to the respondents to comply with the order dated 17/4/2023 passed by this court in WPC number 120/2022. With this observation, this instant IA is disposed of.
Much obliged.
For motion, item number 3.
May I please, Your Lordship? Lordship, this instant I is filed praying for impleadment of Deputy Commissioner Chumuki Dima as respondent number 5 in Civil Division 11 of 2021, Lordship. Lordship, the reason for impleadment is that, Lordship, after the bifurcation of a new district to Dimapur, Lordship, it is informed that all the documents pertaining to the Chumuki Dima district, Lordship, it has been sent to the office of the Deputy Commissioner, Lordship. So it's my humble prayer that if the Deputy Commissioner Chumuki may be implemented as respondent number 5, Lordship.
Heard Ms.
Mika, Lordship.
Mika H.I., learned counsel for the petitioner. Also heard Ms. Livika, learned government counsel. This instant interlocutory application has been filed in connection with Civil Division petition number 11/2021, praying for impleadment of the Deputy Commissioner Chumuki Dima as respondent number 5 in the Civil Division petition number 11/2021. For the reasons mentioned in paragraph number 4 and 5 of the said interlocutory application, learned government counsel does not object to the said prayer. Considering the grounds mentioned in para 4 and 5 of the interlocutory application, the prayer is allowed. The Deputy Commissioner, this interlocutory application is disposed of with a direction that the Deputy Commissioner Chumuki Dima may be impleaded as respondent number 5 in Civil Division petition number 11/2021. With this observation, this IA is hereby disposed of. In Civil Division number 11 oblique in order, heard Ms. Mika H.I., learned counsel for the petitioner. Also heard Ms. Livika, learned government counsel. In view of order passed today, that is 3rd of August 2023, in IA number 82/2023, let the Deputy Commissioner Chumuki Dima be impleaded as respondent number 5 in the instant Civil Division petition. The petitioner shall take steps for issuance of notice to the newly impleaded respondent within a period of 3 days from today.
2 days, Lordship.
Within a period of 2 days from today, returnable within 4 weeks. The steps should be taken for issue. The notice should be issued through registered post with AD.
Your Lordship, I'll serve the copy, Your Lordship.
Okay. You Miss, you will receive the notice.
Yes, Your Lordship.
So last line is not required. As government advocate receives the notice on behalf of newly impleaded respondent, no fresh notices required to be issued. Let this matter be listed after 4 weeks.
Much obliged.
For motion, item numbers 4 and 5.
In the contempt petition, I am appearing on behalf of the respondent number 4, Your Lordship. The interim order of this honorable court has been complied with, Your Lordship.
Why this I?
Lordship, this I was filed for impleadment of respondent number 3. But the moment I've received the compliance order dated 25/8, it has been complied.
So this I becomes infructuous.
Yes, Lordship.
Before that, in contempt in item number 5, first in item number 5, first order, heard Miss
Lordship, let this contempt be closed.
yes, heard Miss, what's her name?
Vikonokiso.
Vikono Kiso, learned counsel for the contempt petitioner, also heard Mr.
Lordship, I am for respondent number 2 and 3.
Mr. Moa M. Chen appearing for respondent number 2 and 3, Mr. N. Angami,
Respondent number 1, my lord.
respondent number 1, and Mr. T. Pongner for respondent number 4. Mr. Pongner produced before this court a letter issued by Joint Secretary to the Government of Nagaland dated 5th of July 2023, inter alia stating that, which shows that the direction issued in WPC number 38/2021 has been complied with. Learned counsel for the petitioner also submits that as the direction issued in WPC number 38 of 2021 has been complied with, this instant contempt petition may be closed. Accordingly, this contempt petition is hereby closed. In I number 83, in view of the order passed today, that is on 3rd of August 2023, in contempt original petition number 15/23, this instant interlocutory application becomes infructuous and hence dismissed on becoming infructuous.
For motion, item number 6.
May I please, Lordship. Lordship, this is filed for impleadment of Upa Lokayukta as respondent number 4 in WPC 130 of 2023, Lordship. Lordship, here the petitioner did not implead the Upa Lokayukta as we were of the assumption that Lokayukta is a court. But we came to realize that it is a statutory body, and without the impleadment of Upa Lokayukta, no effective order may be passed. So here in this item, I praise to implead the Upa Lokayukta.
Whether Upa Lokayukta is a quasi-judicial body or
Statutory, Lordship.
So impleadment is necessary.
Lordship, Lordship.
Anybody who can
So if the Lordship may kindly allow me to implead the Upa Lokayukta as respondent number 4 in WPC 130 of 2023, Lordship.
Okay. In item number 6. Yes, Miss Sukre, help the court. Whether Upa Lokayukta is a quasi-judicial body or only an statutory authority?
I think it's a statutory body.
You also look at it
Lordship,
and come up after some time. If it is a quasi-judicial body, the necessity of impleading, whether there is a necessity of impleading the,
Your Lordship, in this matter, since the Upper Lok Ayukta is not a constitutional body, then subsequent, in all other cases, Upper Lok Ayukta is being impleaded as party, though I realized only subsequent to the filing. So now,
no, otherwise, suppose a judicial authority passes an order. Whether you implead that authority, if you are aggrieved with the order of
yes,
the, normally the judicial authority is not impleaded.
yes, Your Lordship.
Whether Upper Ayukta is under the superintendence of High Court under section 227, no.
It will have to be.
Yes or no? I don't think. These,
Yes, it should be termed as a quasi-judicial authority, Your Lordship, the Upper Lok Ayukta. So if it is a quasi-judicial authority, then Article 226, under Article 26, it will be.
then whether the question of impleadment, then question of impleadment would not arise. If
Your Lordship, in that case, if an order may be, if the order may be reflected that it is not, because on the other occasion, his honorable court was also of the.
no, I'm giving you some
Yes.
time. You come up at 2. I don't want to pass an order without knowing the law. You help the court
Your Lordship.
whether impleadment is necessary or not. If
Yes.
it is necessary, I will pass orders.
Yeah.
Otherwise, at 2.
For motion, item number 7.
May I please, Lordship. Lordship, here the petitioner is working as a work charge. Lordship, as work charge sectional assistant worker on bid scale of pay. White appointment order, and such dated 16 October 1996, Lordship.
No, I am not getting you.
Lordship, the petitioner was initially appointed as work charge sectional assistant
Okay.
on paid scale of pay, Lordship. That is, I have indicated in my paragraph 2 of my petition, Lordship. White order number second such, dated 16 October 1996. Thereafter, Lordship, the petitioner is still continuing in service, Lordship. Now, my grievance is, Lordship, since from the day of the appointment, my salary has not been paid regularly. No doubt, despite of that non-regular, I have been paid till November 2020. Now, Lordship, starting from December 2020, my salary has not been paid, till paid. So, Lordship, I have requested them, my authority, to pay my pending salary.
You have filed a representation.
Lordship.
When? Which para?
Lordship, my representation, I've said it in my paragraph, Lordship. Paragraph 5 of my petition.
Who is appearing for state?
I'm brief, say, Lordship.
Will issue notice?
Yes, madam. Yes, Lordship.
Heard Mr. S. Temjin, learned counsel for the petitioner. Also heard Mr. Enangami, learned. You are appearing for?
All the respondents, my lord.
All the respondents. All the respondents. This writ petition has been preferred by the present petitioner seeking a writ of mandamus directing the state respondent to release the salary of the present petitioner, which has not been paid to him since December 2020. Stop. You need time for seeking.
Yes, Your Lordship. Notice may be issued, Your
Yes.
Lordship, and
Let the notice be issued as, stop, as Mr. N. Hangami, learned senior government advocate, is appearing for all the respondent, no separate notices need to be issued. However, the petitioner shall furnish requisite numbers of the copies of writ petition to the
2 days, Lordship. Within 2 days.
within 2 days to the respondents, so that there is learned counsel for the respondent may seek necessary instruction in this regard. Let this case be fixed after 4 weeks.
For motion, item number 8.
All are same.
Lordship, all are same. Only the nature of appointment, some are in different posts, Lordship. So in this case,
Lordship, nature of appointment and wages are little different from each other. Some are in scale of pay and some are on fixed.
So that I will not mention in
Yes, no need to, yes, as of now, Your Lordship.
Lordship.
number 2.
I may pray for the same respondent, Your Lordship. All the respondents are same in
Item
number 7, 21.
And then it belongs to the same
Item number 8, I am dictating. You write other orders. Item number 8, Mr. S. Temjen, learned counsel for the petitioner, also heard Mr. N. Angami, who appears for all the respondents. This writ petition, nature of appointment.
Lordships, in 2 cases,
No, that we need not to mention now.
Lordship.
Issue notice,
Yes,
issue
Lordship.
notice to the respondent. Stop. As Mr. N. Angami receives notice on behalf of all the respondent, no fresh notices be issued to the respondents. However, the petitioner shall furnish requisite copies of the writ petition along with annexures to the respondent within 2 days from today. Let this matter be listed after 4 weeks.
Lordship.
Now, item number 9 to 21, same order.
Lordship.
Same thing, Your Lordship. The respondents are same, Your Lordship.
Same order in separate orders, but similar order.
Deeply obliged.
Call item number 65.
It's motion.
Yes.
From the supplementary causes for motion, item number 65.
Make this motion. Worship, the petitioner is approaching before this honorable court for the 3rd time on the same related issue. Worship, on the earlier,
Third time.
for the 3rd time, Worship. Worship, in the first case, Worship, this honorable court, Worship, in the first case, the petitioner approached this honorable court by challenging order dated 39/2022, issued by the ex-official registrar of Nagaland, Worship. Convening for a meeting to disannul precedent motion issued by the present petitioner. That order was challenged before this honorable court by filing the petition number 215 of 2022. And Worship, the said petition was disposed of by this honorable court by order dated 4/4/2022.
215/2022, which order you challenge?
Lordship, in the first writ petition, Lordship, I challenged the order dated 39/2022.
What this order is?
Lordship, that is at page number 35. And Lordship, the lengthy order. So Lordship, the operative
What is
portion,
the crux?
yeah, operative portion is
Gist.
page number 38, para 11. Page 38. You are read, Lordship? Para 11.
Yes.
Therefore, I hereby direct by the special conference of all the delegates in terms of the MOA shall be called to assemble on 11th of October 2022 at the Machine Center, Bangkok, Oka, in order to tease the confidence enjoyed by the current office bearers of the LPC and select the office bearers in accordance with the MOA.
What this LCBA stand for?
Which, pardon, Lordship?
This LBCA stand for?
Lota Baptist Churches Association, the present petition.
Okay, okay. So,
Lordship, this order convening a special conference to tease the confidence enjoyed by the present petitioner. That was challenged before this Honorable Court.
okay.
And this Honorable Court disposed of the said petition by order dated 4/4/2023. Lordship, that copy of the order is case number 39.
Yes.
Lordship, the order dated 4/4/2023. And Lordship, this is a lengthy order. Lordship, I'll take your Lordship going to the operative portion. Then we come to page number 56, para 18.
56.
56, para 18. Para 18, Lordship.
Yes.
This is the operative portion. Should you read?
Yes.
In view of the above observation and findings, this court is of the considered view that the Indian order dated 13/9/2022, which is the Indian order, and 7/10/2022, which is the order dated 7/10/2022, is another subsequent order, refixing which is the earlier order, which is the special conference was faxed on 11th of October 2022. Which is by his order 7/10/2022.
Date was
It was
refixed.
different.
Okay.
The Indian order dated 13/9/2022 and 7/10/2022 are not sustainable and should be set aside. Accordingly, they are set aside. The state government, which is the issue start from here. The state government shall not examine the legality or otherwise of the memorandum dated 18/3/2022 passed by the Lota Uhu. Which is this memorandum dated 18/3/2022, which is by this memorandum dated 18/3/2022, the Lota Uhu. These are non-common operation, which is to resolve that petition. So we have approached the state government. The state government has to pass a service for.
Who is petitioner? Petitioner is an association.
Petition is an association.
Luther Baptist Church Association.
Religious registered association.
So by 18/3/2022,
The
Luther Uhu dissolved your association.
Dissolve us. So we approached the state government. The state government has given a protection to us.
Okay.
So on the protection given by the state government, we are still functioning.
After this order of this writ petition.
No. During the pendency of this writ petition, that is the other writ petition.
The earlier writ petition, which was
During the pendency of that writ petition, the writ petition 294.
just
During the period also, the petitioner was functioning on the.
no WPC 294 was disposed of on 4/4/2023.
That's what it should be done like this. We were dissolved by the Lota Hoho on 18/3/2022.
Okay.
We have approached the state government, and the state government has issued a letter dated Sarah's court direction
You approached the state government after this order,
after the 18/3.
not after 4/4.
No, after the 18/3.
But there is a direction in 4/4 order also. That
Which is on page number 34.
No, let me understand.
Yes, sir.
The writ petition number 294/22 was disposed of on 4/4/23,
4/4/2023.
whereby the order which called for this special conference,
That has been quashed aside.
that was quashed aside.
That is our first direction.
And second direction was to the state government to examine the validity of the
Order dated 18/3/2022.
memorandum dated 18/3/2020.
Passed by Lota Hoho.
What has happened to that?
Yes. Lordship, in compliance with the direction passed by this Honorable Court. Lordship, the state government has come with the, in compliance with the direction passed by this Honorable Court. You should become the page number 58.
Yes. What is this?
Notification dated 1st May 2023.
Is this? Just
Yes, Lordship.
what it says.
Lordship, the state government has declared the memorandum of Gauhati as infractions.
Okay, okay.
You should become the page number 5. The next page, paragraph 5.
Okay, infractions.
In view of the above, in regard to the Honorable Court direction to the state government to take a decision on a memorandum dated 18/3/2022, passed by the Gauhati, it is here that the said memorandum has lapsed and ceased to remain in force. Therefore, the memorandum of Gauhati dated 18/3/2022 shall be treated to have become infractions. Now it's
Okay.
no more in existence.
Okay. Now, why are you before this court
Yes,
for the
sir.
third time?
Lordship, again, the state government has issued another order in compliance with the direction passed by this Honorable Court, which will become page number 60.
60
Yes, Lordship. These orders are challenged before this Honorable Court and is still pending.
in the
These orders are challenged.
in the instant case.
No, in the
In the
again, the second petition.
second date petition.
Subdivision number 71 of 2023.
Okay.
Okay, I'll take a look at only the operative portion, Lordship. Paragraph 4.
Yes.
Yeah, wait, Lordship. Paragraph 4.
Yes.
In view of the decision taken by the state government with regard to the memorandum dated 18/3/2022 of the local rule, and then by this office notification number so dated 1/5/2023. That is the notification which I just shown. And further, in the absence of any pending matter before the Honorable Court requiring adjudication, as mentioned in paragraph 5 above, this office letter number dated directing for status quo is hereby withdrawn. The matter, which is the issue starts from here. The matter is referred to the Registrar of Society, Nagaland, under the provision of the Society Registration Act 1860 for early resolution. The Registrar of Societies, having already heard the matter before, shall inquire into the dispute afresh and give a decision within 1 month of the issue of the court. By this order, an issue which has been already crossed by this society. Again, the Home Commissioner has referred the matter to the ex-official Registrar of Society to examine the matter afresh.
No, which matter?
Lordship, the issue regarding which arose from this memorandum dated 18/3/2022 is regarding the functioning of these petitioners.
The Association of
The petitioners. The issue was the Registrar of Society, after examining the matter, issued an impugn order, the 39/2022. And that this 39/2022 has been already passed inside aside by this Honorable Court. Again, now by this impugn order, the present impugn order, 1/5/2023. Again, the state government has directed by its ex-official registrar to examine the matter afresh. So we have challenged this order by filing WBC number 71 of 2023.
Okay. Yeah, that was the second date.
The second date.
And what happened in that?
Lordship, again, the more important, now the issue arises from again the page paragraph 5. In the page 61.
Yes.
Here the decision of the Registrar of Society for further direction in the matter in order to maintain the peaceful atmosphere conducive for settlement of disputes and inquiry of by the Registrar. It is further directed that all the properties of LPC, including those used as office or official residence, etc., at its headquarters in Congo shall be vacated and sealed by the district administration. Again, we are more concerned with this order. Since by this order, well, the
Vacation and sealing of your
we were directed to vacate in the office. So we challenge this order. We should come to the page number 65. This is the order passed, interim order passed in the second read petition. In the operative portion is page number 66. The last paragraph. During the next regional date, the imbued order dated still shall remain state. this honorable court was pleased to stay the imbued order.
Okay.
So, Your Lordship, the issue is, this imbued order now is the issue regarding the office in the official residence of the petitioner at Congress is subject before this court. In this, the action directed by the state government, which has been protected by this interim order. And
This means the interim order passed in secondary petition.
secondary petition has protected us
Okay.
from the eviction, and we are allowed to run our office.
Okay.
In the meantime, Lordship, the Deputy Commissioner Oka, Lordship, has issued this speech number 72. Lordship, we are running our office since this machine center is within a sensitive area. So we are functioning our office in terms of the provisional orders issued by the district ministry. Lordship, we come to page number 72, second bar. Now, therefore, I say so and so, District Magistrate Oka, in exercise of powers conferred under Section so and so of CRPC 1973, do hereby prohibits the assembly of 5 or more persons in one sound machine compound in a perimeter of 20 meters around it. This is a condition imposed by the District Magistrate in the provisional orders. However, we should come to the earlier provisional orders. This is page number 70. Page number 17. I'll read the second paragraph. Now, therefore, I, Sri Ajit Kumar Sunsu, District Magistrate, in interest of power covered under Section 144 of CRPC 1973, do hereby prohibit the assembly of 5 or more persons in one sound machine civil compound within the perimeter of 100 meters around it. Which in the present existing prohibited orders, this condition still exists. But Lordship, the second condition. Further, no group, association on either side shall be permitted to use the office premises at Bangkok Sound Machine Center for holding any meeting. Your Lordship, in the till 17 July 2023, the prohibited orders was passed along with those two conditions. There are two conditions of prohibited orders. In the present
17 May 2023.
till 17 May 2023. In the order passed on 17 July 2023, he has lifted the second condition. The first condition remains, no thought ownership. However, he has lifted the second condition. And Lordship, by taking the advantage of lifting the second condition, the private respondent number 5 get a rebel groups. Now he forcefully entered the machine gun. After the law institution arose in this machine gun. So again, the district magistrate was compelled to pass another prohibited orders in the whole of Okatong, which is page number 73. The two prohibited orders which I referred, that is in respect of this machine compound in this Bangkok Sound Machine Center. In this subsequent prohibited orders, is in respect of in the whole of Okatong. The second paragraph. I now therefore I say so and so, District Magistrate, in excess of powers covered under Section 144 of CRPC 1973, do hereby prohibit the assembly of 5 or more persons in whole of Okatong. The whole issue arose only due to the action of the office bearers of the respondent number 5, the executive secretary in 2 of its office bearers. They are forcefully entered into the machine gun. They not just sheltering there.
Now, with which order you are aggrieved now?
Lordship, we have against the action of the respondent number 5. We have submitted several representation to the respondent authority. the Deputy Commissioner Oka, as well as the former Commissioner Nagani.
Who is respondent number 5?
Respondent number 5 is UFBCR. Here,
This is also a,
here the reform scope. What happened was like this. By the memorandum dated 18/3/2022, issued by the local.
your grievance is against private respondent.
Because the action of the private respondent lodged in the machine. After that,
But if it is against the grievance of private respondent,
Lordship, the private respondent, they are Lordship, I am allowed to clarify the standing of the status of this private respondent. This private respondent, by memorandum dated 18/3/2022, they have dissolved the petitioner and they have considered another group known as the private respondent number 5. So, when the memorandum, this respondent number 5 is a creation of the memorandum issued by the Lota. When the state government declares the memorandum issued by the Lota as infractious, this respondent number 5 association also does not exist. However, a non-existing body, now by taking the law into your own hand, now they have entered into the mission system. That is a clear instruction. So, Lordship, we have submitted a resolution dated 19/7/2023 to the Deputy Commissioner. That is at page number 74.
19 or 20?
19/7/2023, page number 74.
Which number?
Page number 74. Page 74. Worship, here our prayer is prayer to protect, safeguard the Vamosa Mission's senior command, by passing in effective probability orders under certain swimsuit. Worship, this is
But in your prayer portion, go to your prayer
in
portion,
my great petition.
read petition. You have mentioned the date as 27/2023.
Yes, Lordship. Lordship, this is the last representation which I have submitted. Lordship, that is at page number 78. 78 is the representation submitted to respondent number 2 and 3, or respondent number 2. Lordship, now we are moving past with page number 81. Since the respondent number 4 is the district administrator of Upadam. So it is his bonding duty to maintain the law and order within the district. So we come to page number 81.
Yes.
I'm allowed to read it is a short representation. So I'm allowed to read.
What is your grievance against the state respondents?
The respondent number 4. It's the administrator of the district.
Is the administrator of the district?
It is
Yes.
his bonded duty to maintain the law and order. And as well as Lordship, he is the respondent number 5. He is aware about the interim order passed by this group.
But respondent number 5 is a private respondent.
Private respondent. By the interim order dated 4/5/2022, passing the second rate petition. The petitioners has been protected from the eviction. And we are allowed, in the strength of this interim order, we were running the office.
Yes.
We're running the eviction center. During the operation of this interim order, now the private respondent number 5, they have forcefully entered into the eviction center and now they are trying to take the possession.
Violating the interim order. Then you have to approach this, come up with an interlocutory application. You
Lordship,
say,
in the earlier rate petition, the respondent number 5 is not a party. That is a party.
you make him a party.
Lordship, no. Lordship, in the second rate petition, we are challenging only the action of the state government. So respondent number 5 is not a necessary party.
And in this instant writ petition,
In this instant rate petition, since now they are violating the interim order. And the respondent number 4.
But
The Deputy
against,
Commissioner Oka.
against private parties, whether writ lies.
Lordship, now in our prayer also, we are praying for a direction to direct the respondent number 4. So, Lordship, in the prayer portion, we are praying for a direction to direct the respondent authorities to consider and dispose of our representation within the speaking order. Lordship, we come to the prayer portion page number 22 in direct petition. Lordship, the operating portion will be at page number 23. In upon hearing the parties on the causes being shown, be pleased to make the rule obsolete by directing the respondent authorities
Then, okay.
to consider and dispose of the petitioner representation that is ensued by a speaking order, affecting the office bearers of the respondent number 5 from the opposite which is in the interest of justice.
That is at page 81.
Now, yes, Lordship.
That representation is at page 81. Read 81. Is it 81 or?
81, Lordship.
Because at page 78 also there is a.
78 is we have submitted the Home Commissioner Nagaland, the respondent number 2.
No. That
Praying
is,
for a direction to correct the respondent number 2, or respondent number 4.
in your prayer portion, you have mentioned representation dated 27/2023.
Yes, Lordship.
There are 2 representations.
You have submitted on the same day.
And so which representation you are
The last one,
referring to?
page number 81, submitted to the Deputy Commissioner Oka. Page number 78, the same day, that is to the Home Commissioner, to the Governor of Nagaland.
So in your prayer portion, you are referring to this representation
Page
which
81.
is page 81.
81.
Okay. What
Your
is,
Lordship, the respondent number 4 is aware about the pregnancy of this petition in the operation of the interim order. However, due to the inaction of the respondent number 4, the petition is suffering. So we are praying for a direction to direct him to dispose of this petition by a speaking order, affecting the respondent number 5 from the petition.
what is this representation?
Yes, Lordship.
Yes, Ms. Sokri.
Lordship, there is nothing wrong in the Deputy Commissioner in issuing the prohibitory orders because Lordship say it is a dispute among the members of the church group. The majority of the members do not want the present petitioner to continue as office bearers. But
No, he is not challenging the prohibitory orders.
No, nothing, yes. So, Your Lordship, basing on the prohibitory order, he is submitting a representation, Your Lordship, to the government as well as to the DC for disposal, Your Lordship. So, Your Lordship, if that is the case, Your Lordship, as per the prayer, Lordship, the repetition might be disposed, Your Lordship.
Regarding the passing of a non-effective interim order, this has been considered by the respondent number 2 or respondent number 4. He has issued a letter. Regarding the non-effective of passing of non-effective prohibitory orders, he has considered in disposal of our representation by page number 77.
But unless, Your Lordship, when a person is aggrieved, only he can approach this court by challenging order. But nowhere he is aggrieved before this court, just seeking a direction. Will that be a proper, Lordship?
Yes.
The case of grievances, we have submitted the representation. Now it's just sleeping over the Deputy Commissioner.
No, what rights have been violated?
Lordship, my right is.
Your.
Yes, Lordship. Lordship, by this interim order passing this rate petition, we have been forfeited from the election and we were allowed to run our office in the NTC. While we are running our office, the private respondent, number 5, he forcefully entered into the NTC. So we submitted our representation to the respondent number 5, respondent number 4, requesting the effect end. In our representation, page 37, 2023, we have stated in detail. However, it's still remaining silent. And because of the encroachment by the respondent number 5, the petitioners now they are facing difficulty even to run the office. The religious institution.
Lordship, it is an organization, it is a member among themselves who are having the dispute. So, Your Lordship, It's a
Which
very
is
sad.
the Nota Public Charges Association. This is an association where all the charges of the under the Nota jurisdiction has been affiliated under this Nota Public Charges Association. It's a religious institution.
No, maybe, but is it an authority under Section 12, Article 12?
Lordship, yes,
It is a registered society.
It is a registered society.
So,
Whether it lies against them?
Lordship, no, yes, great lies. Since
it does not lie. It does not lie.
no, Lordship. Now we are challenging only that it is an inaction of the state authority.
State has no role in that, Lordship. It's a religious body. There is a freedom of religion, is there, Lordship?
His prayer is, he has designed his prayer in a way that
Exactly.
as if it is a grievance against state.
Lordship, yes. Lordship, will the least property subject before this noble? It is a problem duty of the district administration to even respect and protect and report past by this noble.
Then let us issue notice.
Lordship, otherwise, the matter also can be disposed, directing the government to dispose the representation. Because
That's
the only
good.
prayer is for disposal of the representation and nothing more.
Yes, that is
should be a good speaking order.
Yes.
Heard Mr. Limao Pang, learned counsel for the petitioner. Also heard Ms. V. Sokre, learned additional advocate general. This instant writ petition has been filed by Lotha Baptist Church Association. Has been filed by the petitioner, Lotha Baptist Church Association, Mission Center, Wangkasong, which is a. Who are you? You are a registered society,
Yes, Lordship. Lordship, page number 25 is my registration.
which is a registered society seeking issuance of writ in the nature of mandamus or any other appropriate writ, order of direction to these respondents. Your facts are also respondents directing them to consider and dispose of the petitioner's representation dated 27/2023 by
Specifically, they mentioned Annexure T in the writ petition. And I mean, they are allowed to submit
2023, which is annexed,
Annexure T.
has annexure number T along with the writ petition. Where is the second order? Order where
Page
interim,
number 65.
where interim was granted?
Page number 65.
But this order does not prohibit the DC to pass the prohibitory order. It does not give protection to the petitioner only. It gives the protection to both the two rival groups, Lordship. So the petitioner cannot claim this interim order as his very own. It protects the other group also, Your Lordship.
What is the first May order?
The first
Which was
May
in-
order is at page number 60. In the election notice is at page, which is the appointed portion that will be at page number 5, paragraph 5, page 61.
Learned counsel for the petitioner submits that before approaching this court by filing the instant writ petition, the petitioners had approached this court earlier on 2 occasions. First, by filing writ petition number WPC 294 slash
Two writ petition in this bill order 39, 294 of 2022 and 215 in the bottom. Two writ petitions were discussed of this.
which one? No, I am not getting you.
You should read that page number 39. In this order, for this order, two writ petitions were discussed of.
Okay.
294.
You filed 2 writ petitions earlier or 3?
In the earlier writ petition, you should do this. For the part time. You should in the earlier writ petition.
No, you first understand my query because I have to understand. You know your case. You submitted that you approached this court earlier on 2 occasions.
Yes, sir.
First 294 and later on
215.
215. Now what is this? No, not 215. Later on,
No, in the 215, we have challenged this order dated 39/2022. In 294, we have challenged because the current respondent number 4, they have convened a delegates meeting. We have convened a delegates meeting. Parallel to that, again, the current respondent, they have also convened a delegates meeting on the same day. They also have submitted a permission to the Deputy Commissioner to restrain them. However, the Deputy Commissioner Oka, he failed to restrain them. So we have challenged that.
what was the last line? Two occasions. On the first occasion, the writ petitioners filed 2 writ petitions, namely WPC 294/22 and WPC 215/22, which was disposed of by this court by order dated 4/4/2023, wherein the impugn order dated 3/9/2022 and 7/10/2022 issued by whom?
By the ex-official register.
Where are these impugn orders? You have not annexed.
Ex-official register of societies.
Impugn order 339/2022 and 7/10/2022, which were challenged in that writ petition, were quashed and set aside. And state government was issued direction to examine the legality or the memorandum of legality or otherwise of the memorandum dated 18/3/2022 passed by Lotha Hoho. Lotha Hoho was party to the earlier writ
In the
petition.
writ petition, no.
Stop.
Since the action was under consideration by the state government.
Then what has happened?
You should in compliance with the order passed by the page number 58, the notification was issued, declaring the memorandum as infractions.
In compliance to that order. In compliance, this As page 58, notification was issued in compliance to the order passed in the first state petition.
Yes, Worship. In compliance with the judgment and order dated 4/4/2023.
Thereafter, the Government of Nagaland in Home Department issued a notification dated 1/5/2023 in pursuant to the judgment passed by this court in WPC number 294/22 on 4/4/2023, whereby the memorandum of Lotha dated 18/3/22 was treated as infructuous. Thereafter,
Subsequent order was issued, page 60.
against this page 60, you approach the court again.
Filing the application number 7.
Thereafter, on 1st May 2023 itself, and a subsequent order was issued by the Home Commissioner Nagaland, whereby
Paragraph 0.5, page 60.
whereby the matter was referred to the Registrar of Society Nagaland under the provisions of Societies Registration Act, 1860 for an early resolution, and this vacation order was
Paragraph 5.
until the decision and pending the decision of the registrars of society, it was directed that all the properties of Lotha Baptist Church Association, including those used as office or official residence, etc., at its headquarters in Wangkosum, Wokha, shall be vacated and sealed by the district administration. Stop. Against the said order passed by, after full stop, against the said order passed by Home Commission Nagaland on 1st May 2023, the present petitioner again preferred another writ petition, which was numbered as WPC number 71/2023, wherein this court, by order dated 4/5/2023, issued notices to the state respondent and directed that till the returnable date, the impugn order dated 1st May 2023, issued by Home Commissioner Nagaland, shall be kept in abeyance. Now, the petitioner has alleged that during the pendency of the interim protection, during the pendency of the interim order passed by this court in WPC 71/2023 on 4/5/2023, the private respondent number 5 have tried to trespass into the
They have already trespassed. They have already entered.
have trespassed into the where they have trespassed.
Wangkosang Mission Center headquarters.
in trespassed into the Wangkosong Mission Center compound
On 18/7/2023.
on 18/7/2023, and thereafter the petitioner has approached the Deputy Commissioner Woka and filed a representation on 27/2023 with a request to protect and safeguard the Wangkosong Mission Center compound. Now, in the instant writ petition, the prayer is to direct the state of the respondent. Deputy Commissioner is respondent number?
Respondent number 5.
Direct the respondent number 5.
4
to consider the representation filed by the present petitioner and dispose of it by a speaking order. Heard, Miss V. Sukre, not heard. Miss V. Sukre, learned additional advocate general, submits that in view of the facts and circumstances of this case, the present writ petition may be disposed of with a direction to respondent number 5 to consider the representation dated 27/2023 within a reasonable time and dispose it of by a speaking order. Stop. In view of submissions made by learned counsel for the petitioner as well as learned additional advocate general, this writ petition is hereby disposed of with the direction that respondent number 5. Respondent number 4, that is Deputy Commissioner Woka, Nagaland, shall dispose of the representation dated 27/2023, which is annexed as Annexure T along with the instant writ petition within a period of
Lordship, 3 months.
No, Lordship, that is too long.
No,
Just to
Lordship,
within 10 days.
Lordship, there's Woka, then the situation is also then, so.
Lordship, within 10 days.
No, that cannot be, Your Lordship.
Now, what is your prayer in the representation? Representation prayer is
Representation is to Lordship, by considering the interim order passed by this rule, we are going to affect the
within 15 days.
No, Your Lordship, Lordship,
No, otherwise the property.
No, exactly. No, Your Lordship, it's not only the property of the petitioner, Lordship.
No.
There are 140 churches members in the associations.
No, you have to only consider their representation.
That's what, Your Lordship. So at least, Your Lordship, make it 45 days, Your Lordship. At least, Your Lordship.
Oh, no, Lordship, that is too much.
Lordship, 45 days. Because the situation is very tense. Because of that reason,
Therefore, no, as the situation is tense,
yes.
therefore administrative authorities have to act
Exactly,
expeditious.
Lordship, exactly. But it involves, it's a very sensitive issue, Your Lordship.
15 days if you.
Lordship, 15 days or 45 days may be granted, Your Lordship.
No,
or at least 1 month.
You take a decision on this representation. If you get a difficulty in disposing it off, you may come to the.
For extension of time.
Because you are issuing 144 orders.
Lordship,
That itself says.
my prayer is that in the interest of justice, Your Lordship, at least 1 month may be given to Your Lordship. 1 month, Your Lordship, because petitioner may be directed to furnish extra copies, Your Lordship.
Yes, I should exactly I'll do that.
No, I am disposing it off.
No, in order to serve the repetition to the concerned respondent, Your Lordship.
By tomorrow itself, we'll serve the extra copy to the customer.
No, what was your prayer in the representation?
Page 82. Therefore, considering the sensitivity of the issue at hand, we understand on behalf of the LDC, University goes to immediately evict the honorable rebel groups, member led by Serisu and Su, presently lodging at the official residence in Wangkosong Central Headquarters. In further pass of fresh probate orders in excess of our administration with appropriate terms and conditions. so as to protect and safeguard.
Otherwise, the prohibitory
They are
order,
asking for eviction.
prohibitory order is also already
It's
there.
clear, but it's not effective. And
And if there is a violation of the earlier court's order in second writ petition, you have to approach there only. That in that case only.
Lordship, the difficulties were aggrieved by the action of the respondent number 5 entering into the mission syndrome. In the earlier writ petition, they are not a party. Lordship, in that case, the presentation will dissolve within the period of 20 days.
What is the last in a period of 1 month? 1 month. The petition.
By taking into consideration the interim order passed by this window, that will be condemnation.
No, because you have mentioned everything in your representation. If it is mentioned in the representation, they will. Otherwise, repeat.
Lordship, sometimes we face difficulty to deal with the district administration. So unless there is a specific order passed by this window.
Just
The
dispose of
petition,
that's all,
the
you know.
petitioner shall furnish extra copies of the writ petition, necessary numbers of extra copies of the writ petition to the learned additional advocate general by tomorrow, within 2 days.
By tomorrow.
By tomorrow. With above observation, this writ petition is hereby disposed of.
Much obliged.
For admission, item number 31.
May I please, Your Lordship? My Lord, let the matter be taken up after part 1. We are ready for hearing, my Lord. Yes, my Lord.
Yesterday also you made this matter was listed yesterday also, no?
Yes. No. Day before yesterday.
Day before yesterday, but it could not reach.
Yes.
Okay.
After listed matters.
After listed matter.
Pleasure.
For admission from the supplementary course list, item number 66.
What's the regime? May it please Your Lordship. Your Lordship, this court by order dated 30th of May 2023 has directed the State Council to obtain instruction, Your Lordship. And in this regard, Your Lordship, in compliance to this court's order, Your Lordship may allow me to place.
What was the order? 35/2023. What is the matter in this case?
Yes, Your Lordship, here the petitioner is seeking for regularization. And on the last occasion, on 25th May 2020, this year, Your Lordship, when this matter was taken up for admission hearing, this honorable court was of the view that the state respondents have to come up with instructions with regard to the RTI. RTI that was furnished to the department, furnished by the department to the petitioner, Your Lordship, with regard to the 195 road charge employees who were regularized. And all of them were junior to the petitioner. However, the petitioner was not regularized. So that was the instruction that this honorable court was seeking.
Lordship, may allow me to place a copy of the instruction.
Yes, and before that, just a minute. Yes. You were requested to inform this court as to why, on what basis the juniors to the petitioners were given scale of pay and their services were regularized.
Yes, Your Lordship.
And
So
why?
by speaking, Your Lordship, on that, Your Lordship, the letter dated June 2023, they have explained as to how juniors were given upgraded. Some of the juniors.
Letter dated
Letter dated
9 June.
9 June, Your Lordship. That I placed, Your
What
Lordship.
they have stated.
Yes, Your Lordship. And also, Your Lordship, I have received the information from the department that similarly situated person has approached this court, Your Lordship. And in the WPC, Your Lordship, I've already placed before Your Lordship. WPC 2021, Your Lordship. Here, relief has been granted to the petitioner, Your Lordship. So against this, Your Lordship, state has filed an appeal before the division bench, which is pending for hearing, Your Lordship. So, Your Lordship, it is at hearing stage, Your Lordship. The outcome will have a bearing in the present instant case, Your Lordship. My learned friend, the petitioner here, the counsel is the Your Lordship representing as a respondent, Your Lordship, in that writ appeal.
So what is your prayer?
Lordship, if the matter can be listed after the appeal is disposed.
Yes, Your Lordship, I have no objection to that.
Okay. But whether this submission was not made on last occasion before this court, when the court directed the state respondent to furnish.
Earlier, the brief is with my learned friend, Lucine Su, Your Lordship. But since she is not in good shape, Your Lordship, the matter has been endorsed to me. So I don't know whether that submission has been made on earlier occasion.
Okay. Heard Ms. V. There, learned counsel for the petitioner. Also heard Ms. S. Mere,
Yes, Your Lordship.
learned senior government advocate, who placed on record a letter dated 9/6/2023, issued by Chief Engineer, PHED, Sanitation and WSSO, Nagaland, Kohima, addressed to Senior Government Advocate mentioning therein the circumstances under which the employees junior to the present petitioners were granted scale of pay and some of them were regularized. Let the said letter be part of this record. Ms. S. Mere has, learned senior government advocate, has on the other hand has also submitted that some of the similarly placed employees had preferred writ petitions before this court, in which relief were granted by the writ court to those petitioners, and against the said order, the government has preferred an appeal which is registered as
WA35 2022.
2022.
Yes, Your Lordship.
And it is submitted that the outcome of the said writ appeal would have a bearing in the instant
Yes, Your Lordship.
writ petition.
Yes,
And therefore it is prayed for that the instant writ petition may be listed for consideration after disposal of the said writ appeal.
Yes, Your Lordship.
Ms. V. There, learned counsel for the petitioner does not object to the prayer made by learned senior government counsel. Hence, let this writ petition be listed again after disposal of the writ appeal number so and so. I'm not giving any time.
Lordship, regarding the compliance of the court's order, Your Lordship, may kindly pass an order.
Yes. Before these submissions by Ms. Before this paragraph of submissions by learned, where I have the last line was the let this letter be part of the record. After that, the order dated 30/5/2023 is thus complied with by learned senior government advocate. Stop. Thereafter. So let it be listed after disposal of the.
Lordship, I'm obliged.
For orders, item number 35.
Please, Lordship. Lordship, my senior Mr. N. Moser, he'll be appearing for respondent number 4. If 4 weeks' time may be granted to file affidavit. Lordship, they have not filed their affidavit till date, so this may be the last chance. No further adjournment, Lordship.
Miss,
N. Repreo.
what's her name? Repeat again.
N. Repreo.
N. Write her name. Who submits that her senior Mr.
N. Muzoy.
M. Muzoi will be filing affidavit in opposition and seeks 3 weeks time for the same. Mr. Form, you are appearing.
My Lord, I'm appearing for Inaholi, State Council, on behalf of Inaholi.
You also,
Respondent 1, 2, 3. Yeah.
you have filed your.
Yes, they are filed and we have received.
Mr. E. Tiba Form appears for respondent number 1 to 3. On the other hand, Ms. Desino Queso, learned counsel for the petitioner, submits that the state respondents have. No, this
Accountant General, Respondent 4. They have not filed their affidavit in opposition till date. Lordship.
How many dates were earlier? Okay. Earlier also several opportunities were granted to the respondent number 4.
Lordship.
However, they have not filed their affidavit in opposition, therefore last chance may be granted to them. Considering the submissions made by learned counsel for the parties, one more opportunity is given to respondent number 4 for filing affidavit in opposition. Let this case be affidavit in opposition before the next date fixed. Let this case be fixed after 3 weeks.
Lordship, if the name of my senior can be reflected in the coast list.
The name of Mr. N. Muzoi, registry to show the name of Mr. N. Muzoi as counsel for respondent number 4 henceforth.
Let's Lordship.
For orders, item number 36.
Please, Lordship. Notice is still awaited, Your Lordship. I may be allowed to take first steps upon respondents through registered AD.
Heard Miss Supangwati, Arsula Kips learned counsel for the petitioner, who submits that the notice issued to the respondents have not yet returned back and their service report is still awaited, and prays for allowing the petitioner to take fresh steps for issuance of notice on the respondents. The prayer is allowed. The petitioner shall take fresh steps for issuance of notice to the respondents through registered post with AD
Within 3 days.
within 3 days from now, returnable within 4 weeks.
Much obliged.
Let this matter be listed after 4 weeks.
My pleasure.
For hearing, item number 46.
City Samir, none appears. After some time.
May I please, Lordship, I'm mentioning on behalf of Moa Engine. I'm informed that he is yet to file additional affidavit. So kindly list the matter after 2 weeks, my lord.
Item 46.
Yes.
Your form
For the state respondent.
heard,
On behalf of Moa Engine, State Council.
none appears for the writ petitioners on call. Mr. T. E. Tibafong, learned counsel for the learned government counsel, who appears for Mr. Moa Im Chen, learned senior government counsel, submits that state respondents are yet to file their affidavit in opposition,
Additional affidavit.
and state respondent shall be filing additional affidavit in opposition and seeks
2 weeks time.
2 weeks time for the same. Considering the submissions, the prayer is allowed. Let this matter be listed after 2 weeks.
Much obliged.
For admission, item number 31.
May you please lodge you. Lordship, this is the third round of litigation before this honorable court, Lordship, including a contempt petition, Lordship. I'm aggrieved by a communication made by the Commission of the State of Nagaland, Lordship. I've challenged the letter addressed to the petitioner, Lordship. Now, what has happened in the earlier petition, I have approached this honorable court seeking for a minimum scale of pay, Lordship. I'm serving as a sweeper for the last 20 years, Lordship.
Okay. Yes.
Lordship, in the earlier read petition, when I approached this honorable court, while disposing the read petition, has given a direction to the state of Nagaland, more particularly to Commissioner Lordship, to consider my representation in terms of the law laid down by the Honorable Apex Court in the case of Jagjit Singh versus State of Punjab, Lordship, reported in 2017, Volume 1, SSC, page 148, Lordship. Now, despite of that clear direction, Lordship, the principle has not been considered, Lordship. Now, the law is very clear as far as the case referred by this honorable court is concerned, Lordship. Lordship, for clarity, if I may be allowed to take your Lordship to the direction by this honorable court, Lordship, while disposing the read petition, Lordship. Page 28, Lordship. Page 28, Annex LG, Lordship.
Yes.
If your Lordship got it, Lordship.
Yes.
The order starts from page 29. This is order dated 21st of January 2022, Lordship. May I read it, Lordship? It is a short order, Lordship.
Yes, yes.
Per Mr. So-and-so, counsel appearing for the petitioner. Briefly stated, the petitioner's case is that though he enjoyed the scale pay as per ROP
1993, when he was initially appointed in the year 2003 as sweeper on temporary basis in the office of the IDC Kifri. His scale of pay has remained stagnant in spite of the fact that 3 ROPs, that is 1999, 2010, 2017, have been implemented in the state of Nagaland, and all the employees of the state government have been given the benefits. Therefore, he should also be given the benefit of the latest ROP, that is ROP 2017. This ROP is still holding a field logic. In support of the case of the petitioner, Mr. So-and-so learned counsel has referred to paragraph 57 and 58 of the judgment passed in the case of State of Punjab and others versus Jagdeep Singh, and others reported in 2017, volume 1 SSC, page 148. Contents of the 2 paragraphs are reproduced here below. Paragraph 57. There is no room for any doubt that the principle of equal pay for equal work has emerged from an interpretation of different provisions of the Constitution. The principle has been expounded through a large number of judgments rendered by this court and constitutes law declared by this court. The same is binding on all the courts in India under Article 141 of the Constitution of India. The parameters of the principle have been summarized by us in paragraph 42 herein above. The principle of equal pay for equal work has also been extended to temporary employees under bracket differently described as workers, daily wage, age, ad hoc contract, and the like. The legal position relating to temporary employees has been summarized by us in paragraph 44 here and above. The above legal position, which has been repeatedly declared, is being reiterated by us yet again. Paragraph 58, Lordship. In our considered view, it is fallacious to determine artificial parameters to deny fruits of labor. An employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities, certainly not in a welfare state. Such an action, besides being demeaning, strikes at the very foundation of human dignity. Anyone who is compelled to work at a lesser wage does not do so voluntarily. He does so to provide food and shelter to his family, at the cost of his self-respect and dignity, at the cost of his self-worth, and at the cost of his integrity. For he knows that his dependents would suffer immensely if he does not accept a lesser wage. Any act of paying less wages as compared to others similarly situated constitutes an act of exploitative enslavement emerging of a domineering position. Undoubtedly, the action is oppressive, suppressive, and coercive, as it compels involuntary subjugation. But Ms. So-and-so, the government advocate appearing for the state respondents. It appears from the appointment order of the petitioner issued by the Additional Deputy Commissioner dated 2003, which is at Annexure A to the read petition, that the petitioner was appointed as sweeper on temporary basis with a scale pay of ROP 1993. Further, it also appears from the document at Annexure 1 of the read petition, which is information provided by the APIO of the Office of Deputy Commissioner Kifri, that the petitioner's pay scale has never been revised since his appointment as sweeper on temporary basis. The principle of law on granting equal pay to employees who are appointed on work charged temporary basis has been settled in the judgment cited by the learned counsel. However, since this case is only at the motion stage, without going so much into the merit, it is disposed of with a direction that the respondent should consider the representation of the petitioner, which is at Annexure J to the read petition, in the light of the principle of law settled by the Honorable Supreme Court and followed by the courts in this country within a period of 3 months from the date of receipt of a copy of this order. This petition is accordingly disposed of. Lordship, despite of the lapse of 3 months, Lordship, the respondents did not consider my representation. I was compelled to approach this honorable court by way of a contempt petition, Lordship. And when the contempt petition was pending, Lordship, I received the impugned letter, Lordship. It was dated 6th of May 2022. Lordship, and that is how I withdraw the contempt petition with a prayer that I will challenge the impugned letter, and that is how I'm before this honorable court, Lordship.
Okay. Your representation was rejected.
It was rejected, Lordship. However, my contention in this case is that the principle laid down by the Honorable Apex Court was not considered, Lordship.
What was the ground for rejection?
Rejection, I'll come to that, Lordship. If I may be allowed to take your Lordship to page 32, the next page, annexure H.
Yes.
This is the impugned letter, Lordship.
Which was placed by the respondent in the contempt. Yes.
Yes, Lordship.
Okay.
Accordingly, I have withdrawn the contempt petition and challenged this impugned letter by this re-petition, Lordship. It is letter dated 6th of May 2022. This was communicated by the Commissioner in Nagaland, Kohima, Lordship. May I read it, Lordship? The content?
Yes.
Sir, you have preferred the above re-petition before the Honorable High Court, Kohima Branch, claiming for granting of skilled pay in terms of the latest ROP, that is ROP 2017. This Honorable Court took up the matter for motion on 21st of January 2021, and without going so much into the merit, disposed the matter directing the state respondents to consider representation submitted by you on 28/10/21 to the Deputy Commissioner Kifre Nagaland. As such, the state respondent number 3 on its capacity would like to respond and clarify upon your representation accordingly. Your representation has been examined to ascertain and to consider the claim placed by you. On going through all available records, the following facts of your case have been established, and I am to respond and clarify your claims as under 1. That as stated in your representation, you have been initially appointed in the capacity of sweeper at the time residence of ADC Kifri and later on transferred to the ESC office, which are matter of record and therefore need no further comments. So there is no dispute with regard to my appointment, with regard to my service records, Lordship. Second, that it is also evident that you have been appointed on temporary basis, which clearly implies that your appointment was accorded without any sanctioned post. They are concerned with only the sanctioned post, Lordship. My post is temporary. You were appointed without any sanctioned post. That is the first contention that they have raised, Lordship. The third paragraph, Lordship. That in regard to your claim for the benefit of pay under the latest ROP rules, that is the rules of 2017, on the principle of law on equal pay for equal work is concerned, it is a settled position governed by the Nagaland Services Revision of Pay Rules 2017. While Government of Nagaland Finance Department Establishment Branch so dated 16th of December 2017. ROP Rules 2017 apply only to regular employees. This is the second contention, Lordship. The first, my appointment is temporary. I was appointed without sanction post. Despite of the law, which is very clearly settled by the Honorable Apex Court, we are playing reliance on the Revision of Pay Rules 2017. Lordship knows the rules found under Article 309 cannot override a precedent, Lordship. A precedent under Article 141. So this is the second contention, Lordship. If I may be taken, Lordship, to the next page, Lordship.
Yes.
Page 33. On the premises above, given the circumstances that they have been appointed without sanction post, until such time the notification number dated 16/12/2017 is in place, I do not find any merit in your claim for grant of pay scale in terms of the latest ROP 2017. Therefore, this letter is in accordance with the direction of this Honorable Court order dated 21st of January 2022 to inform you that your representation cannot be entertained.
Your prayer was for getting
a law declared by Supreme Court is binding on all the courts all over the country, Lordship. And it is just a mere rules framed under Article 309, Lordship. That cannot and should not override, Lordship.
Yes.
I may be allowed to place reliance on the decisions of the Honorable Apex Court, Lordship. First, Lordship, if I may be allowed to place reliance on the state of Punjab versus Jagjit Singh, Lordship. state has also filed affidavit, Lordship. They are taking the similar ground, Lordship, as taken in the while rejecting my representation. I have also filed my reply, Lordship. If I may be allowed to take your Lordship to paragraph 44, Lordship. Lordship will find it page 209, Lordship.
Just a minute.
This is citation is 2017 1 SSC, page 148, Lordship.
Page,
Paragraph, relevant paragraphs 44, 49.1, Lordship, 57, 58, 59, and 60, Lordship. Lordship will find paragraph 44, page 209, Lordship. Page 209, Lordship.
long judgment.
Yes. Lordship, correct. May I read the Lordship? It is a short paragraph, page 44, Lordship.
Yes.
We shall first outline the conclusions drawn in cases where a claim of pay parity raised at the hands of the temporary employees concerned was accepted by this court by applying the principle of equal pay for equal work with reference to regular employees. Lordship, in this case, pattern of decisions rendered by the Honorable Appellate Court has been discussed, Lordship. If I may be allowed to take your Lordship to all the paragraphs, Lordship, starting from 44.1, Lordship. In the case of Tilendra case, Lordship, it is reported in the year 1986, 1 SSC 637, Lordship. This court examined a claim of pay parity raised by temporary employees for wages equal to those being dispersed to regular employees. The prayer was accepted. The action of not paying the same wage despite the work being the same was considered as violative of Article 14 of the Constitution. Very clear, Lordship, it is crystal clear. It was held that the action amounted to exploitation in a welfare state committed to a socialist pattern of society. That is the principle laid down in this case, Lordship. 44.2, if I may be allowed, Lordship.
Yes, yes.
Surinder Singh's case, Lordship. It is reported in the year 1986, 1 SSC 639, Lordship. This court held that the right of equal wages claimed by temporary employees emerged inter alia from Article 39 of the Constitution. The principle of equal pay for equal work was again applied, where the subject employee had been appointed on temporary basis and the reference employee was born on the permanent establishment. This is very important, Lordship. The temporary employee was held entitled to wages drawn by an employee on the regular establishment. In this judgment, this court also took note of the fact that the above proposition was affirmed by a constitution bench of this court in DS Nakara case. Next paragraph, Lordship. Next paragraph, Lordship. Next page, 44.3, Lordship.
Yes.
In so-and-so case, which is reported in 1987, Volume 1 SSC 634, Lordship, this court recorded that in a claim for equal wages, the duration for which an employee would remain or had remained engaged would not make any difference, Lordship. So also the manner of selection and appointment would make no difference. This is also important, Lordship. And therefore, whether this selection was made on the basis of open competition or was limited to a cluster of villages was considered inconsequential, Lordship. Inconsequential. insofar as the applicability of the principle is concerned. And likewise, whether the appointment was for a fixed limited period, under bracket 6 months or a year, or for an unlimited duration was also considered inconsequential, insofar as the applicability of the principle of equal pay for equal work is concerned. It was held that the claim for equal wages would be sustainable, where an employee is required to discharge similar duties and responsibilities. This is the only criteria, Lordship. I should discharge similar duties and responsibilities as those of regular employees, Lordship. And the employee concerned possessed the qualification prescribed for a post. In the above case, this court rejected the contention advanced on behalf of the government that the plea of equal wages by the employees in question was not sustainable because the employees concerned were engaged in a temporary scheme and against posts which were sanctioned on a year-to-year basis. Lord. This is also very clear. 44.4, if I may be allowed, Lord, to the next paragraph.
Yes.
This is reported in the year 1988, Volume 1, SSC 122, Lord. This court held that under the principle flowing from Article 38, 1 of the Constitution, the government could not deny a temporary employee at least the minimum wage being paid to an employee in the corresponding regular quarter, along with dearness allowance and additional dearness allowance, as well as the other benefits which were being extended to casual workers. It was also held that the classification of workers as unskilled, semi-skilled, or skilled, doing the same work into different categories for payment of wages at different rates was not tenable. It was also held that such an act of an employer would amount to exploitation, and further that the same would be arbitrary and discriminatory and therefore violative of Articles 14 and 16 of the Constitution, Lord. 44.5, Lord. Paragraph 44.5. In the state of Punjab versus Devendra Singh, reported in 1998, Volume 9, SSC 595, this court held that daily wages were entitled to be placed in the minimum of the pay scale of regular employees working against the same post. The above direction was issued after accepting that the employees concerned were doing the same work as regular incumbents, holding the same post by applying the principle of equal pay for equal work. 44.6, Lord. This is the case of Umadevi, Lord, State of Karnataka versus Umadevi, reported in the year 2016, 6th, Volume 4, SSC 1, Lord. The Constitution bench of this court set aside the judgment of the High Court and directed that daily wages be paid salary equal to the lowest grade of salary and allowances being paid to the regular employees. Importantly, in this case, this court made a very important distinction between pay parity and regularization. This is also important, Lordship. It was held that the concept of equality would not be applicable to issues of absorption regularization. Lordship, why this is important in this case is, Lordship, they have taken the stand that I should be appointed against the sanction post. I'm not seeking for regularization, Lordship. I'm seeking for minimum scale of pay, Lordship. The state responses are perplexed, Lordship. They are confused as to what their stand is, Lordship. Sanction post is irrelevant in my case, Lordship. Which one? My humble prayer before the Son of God. I'll be seeking the prayer for regularization only if I am eligible, Lordship. Till such time, Lordship, I'm at the moment, Lordship, for
because
this.
There are government memorandums, OMs,
exactly, Lordship,
governing regularization.
Lordship. Lordship is well aware, Lordship, that the similar matter was taken up yesterday, Lordship.
So
I should complete 30 years.
You will
Lordship.
wait 30 years.
Exactly, Lordship. Exactly.
Okay.
Grateful, Lordship. If I may continue, Lordship.
Yes.
But the concept was held as applicable and was indeed applied to the issue of pay parity.
Umadevi said pay parity and regularization are different concepts.
Exactly, Lordship. Exactly, Lordship.
Okay.
And it is a celebrated judgment, Lordship, 2006. The judgment rendered by the High Court was modified by this court, and the daily wage employees concerned were directed to be paid wages equal to the salary at the lowest grade of the cutter concerned. 44.7, Lordship. I'm coming to the end of this para 44, Lordship. In the state of Haryana versus Jalanjit Singh, Lordship. This is reported in the year 2006, 9 SSC, page 321, Lordship. A three-judge bench of this court held that the decisions rendered by this court in the case of Haryana versus Jasmine Singh, state of Haryana versus Tilak Raj, Orissa University of Agriculture and Technology case, and the state of West Bengal laid down the correct law. Thereupon, the court declared that if the daily wage employees concerned could establish that they were performing equal work of equal quality and all other relevant factors were fulfilled, a direction by court to pay such employees equal wages from the date of filing of the writ petition would be justified. I may take your Lordship to the next paragraph, 44.8, Lordship. The state of UP versus Pudi Land, Lordship. It is reported in the year 2006, volume 9, SSC 337, Lordship. Based on decision
You are otherwise doing the work of a sweeper.
Lordship.
So have you shown what other sweepers are getting?
Yes, Lordship. I have enclosed in my paragraph, Lordship. In my petition, Lordship.
What salary they are getting?
Yes. I have sought information through Right to Information Act, Lordship. They have furnished me an information. A regular sweeper is granted scale of pay in terms of ROP 2017, Lordship. 2017. That is the latest ROP which is working the field.
And that is your claim?
That is my claim, Lordship. And I'm claiming for a minimum scale of pay, Lordship. I've also stated abnormalities in my writ petition. State has filed their counter affidavit. It has been admitted, Lordship. I'm discharging the same duties and responsibilities, Lordship. Clearly admitted, Lordship. May I continue, Lordship?
Yes.
44.9, Lordship. In the case of UP Land Development Corporation case, this court noticed that the respondents were employed on contract basis on a consolidated salary, but because they were actually appointed to perform the work of the post of assistant engineer, this court directed the employer to pay the respondent wages in the minimum of pay scales ascribed for the post of assistant engineer, Lordship. Now, Lordship, if I may be allowed to take your Lordship to 49.1, Lordship, page 216. Lordship, page 216.
Yes.
May I read it, Lordship?
Yes.
We are of the considered view that in paragraph 44 extracted above, which I have just read, Lordship, the Constitution bench clearly distinguished the issues of pay parity and regularization in service. It was held that on the issue of pay parity, the concept of equality would be applicable under bracket as had indeed been applied by this court in various decisions. But the principle of equality could not be invoked for absorbing temporary employees in common service or for making temporary employees regular permanent. All the observations made in the above extracted paragraphs relate to the subject of regularization, permanence, and not on the principle of equal pay for equal work. As we have already noticed above, the Constitution bench unambiguously held that on the issue of the pay parity, the High Court ought to have directed that the daily wage workers be paid wages equal to the salary at the lowest grade of their cutter. This deficiency was made good by making such a direction.
Which line the High Court ought to have
directed that the daily wage workers be paid wages equal to the salary at the lowest rate of their cutter. That is the observation, Lordship. Now, Lordship, if I may be allowed to take your Lordship to paragraph 57, Lordship. Page 222, 222, Lordship. 57, Lordship.
Yes.
There is no room for any doubt that the principle of equal pay for equal work has emerged from an interpretation of different provisions of the Constitution. The principle has been expounded through a large number of judgments rendered by this court. Constitutes law declared by this court, the same is binding on all the courts in India under Article 141 of the Constitution of India. The parameters of the principle have been summarized by us in paragraph 42 here and above. The principle of equal pay for equal work has also been extended to temporary employees. Under bracket, this is also important, Lordship, differently described as work charge, daily wage, casual, ad hoc, contract, and the like, Lordship. So temporary employees are these categories of employees, Lordship. The legal position relating to temporary employees has been summarized by us in paragraph 44 here and above. The above legal position, which has been repeatedly declared, is being reiterated by us yet again. Paragraph 58, Lordship. In our considered view, it is fallacious to determine artificial parameters to deny fruits of labor. An employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities. Certainly not in a welfare state. Such an action, besides being demeaning, strikes at the very foundation of human dignity. Anyone who is compelled to work at a lesser wage does not do so voluntarily. He does so to provide food and shelter to his family, at the cost of his self-respect and dignity, at the cost of his self-worth, and at the cost of his integrity. For he knows that his dependents would suffer immensely if he does not accept the lesser wage. Any act of paying less wages as compared to others similarly situated constitutes an act of exploitative enslavement. Emerging out of a domineering position, undoubtedly the action is oppressive, suppressive, and coercive as it compels involuntary subjugation, Lordship. The last paragraph,
This was quoted in your earlier.
Exactly, Lordship. Yes, Lordship. Paragraph 57 and 58, Lordship. The last paragraph, Lordship. 60, Lordship.
There are 60.
60, Lordship. Page 224, Lordship.
Yes.
Having traversed the legal parameters with reference to the application of the principle of equal pay for equal work in relation to temporary employees, the sole factor that requires our determination is whether the employees concerned were rendering similar duties and responsibilities as were being discharged by regular employees holding the same corresponding post. This exercise would require the application of the parameters of principle of equal pay for equal work summarized by us in paragraph 42 above. However, insofar as the instant aspect of the matter is concerned, it is not difficult for us to report the factual position. We say so because was fairly acknowledged by the learned counsel representing the state of Punjab that all the temporary employees in the present bunch of appeals were appointed against posts which were also available in the regular cutter establishment. It was also accepted that during the course of their employment, the temporary employees concerned were being randomly deputed to discharge duties and responsibilities which at some point of time were assigned to regular employees. Likewise, regular employees holding substantive posts were also posted to discharge the same work which was assigned to temporary employees from time to time. There is, therefore, no room for any doubt that the duties and responsibilities discharged by the temporary employees in the present case, sets of appeals were the same as were being discharged by regular employees. It is not the case of the appellants that the respondent employees did not possess the qualifications prescribed for appointment on regular basis. Furthermore, it is not the case of the state that any of the temporary employees would not be entitled to pay parity on any of the principles summarized by us in paragraph 42 here and above. There can be no doubt that the principle of equal pay for equal work would be applicable to all the temporary employees concerned so as to vest in them the right to claim wages on a par with the minimum of pay scale of regularly engaged common employees holding the same post. This is very clear, Lord. This quality covers my case, Lordship. Now, Lordship, some decisions rendered by this Honorable Court, Lordship. In a similar cases, if I may be allowed to refer, Lordship.
Yes.
2023, Volume 1, Nagaland Law Journal, Lordship. Page 67, Lordship. Volume 1, Nagaland Law Journal, page 67, Lordship. Lordship, I'll read only the relevant paragraphs, Lordship. Paragraph 13, Lordship. Lordship will find it page 72, paragraph 13, page 72, Lordship.
Yes.
This has reproduced the paragraphs of Jagjit Singh, Lordship. I need not repeat it again, Lordship. Paragraph 13, page 72, if your Lordship got it. Again, in the case of Jagjit Singh, Honorable Supreme Court has held as entered, Lordship. Paragraph 58
We have
and
already
60,
read.
Lordship. Yes, Lord. May I refer to paragraph 14, Lordship?
Yes.
Paragraph 14. Since the petitioner has been discharging the same duty with that of his colleagues, whose services have been regularized and drawing much less salary than his colleagues, his right to pay equal pay for equal work as enunciated by the Honorable Supreme Court in the case of Randir Singh and Jagjit Singh appears to have been violated here in this case. The doctrine of equal pay for equal work, as has been held in the aforesaid cases, can be applied here in these cases so as unequal scale of pay based on no classification or irrational classifications being given to the employees for doing identical work under the same employer. The above legal as well as factual position have not been disputed by the learned government advocate. 15. In view of the above, this writ petition stands disposed of at this stage by directing the state respondents to pay petitioner the same scale of pay, Lordship.
Yes.
Lordship, what has happened? The state has preferred an appeal, Lordship.
Against this?
Yeah, against this, Lordship. And it was dismissed, Lordship. I have the judgment, Lordship. It was this. They have preferred an writ appealed 29 of 2022, Lordship. I have finished a copy of the appeal, Lordship.
Can you furnish a photocopy of this judgment?
Photo of the appeal, Lordship?
No. The
Nagaland Law Journal,
Nagaland Law Journal.
Yes, Lordship. I can finish, Lordship.
This writ appeal, you have writ appeal 29.
Writ appeal 29 of 2022, Lordship. The state has preferred an appeal, but it was dismissed by an order dated 13/12/2022, Lordship. I have finished a copy of the appeal, Lordship. The relevant paragraphs are paragraph 13, 15, and 16, Lordship. 13, 15, and 16.
Yes. At 2, we will
Lordship,
continue.
Lordship.
Lordship, I beg your order to indulgence to mention item 63. Hearing, Lordship.
Item 63.
Lordship, this matter will be taken up on Tuesday, on 8th. I have taken the concern of the other bodies.
Okay, item 63 on Tuesday. Okay, I'll dictate it. Prayer is allowed
Lordship. On 8th.
on the 8th of
August.
May I please, Lordship?
Steno. Yes. Yes.
Lordship, I beg to mention hearing item 56, 7 and 8. Lordship, kindly post this matter for hearing on 8th of August, that is Tuesday. I have also sought the consent of the petitioner. I am the sole respondent here.
What is your name?
Ali Boscom, Lordship.
Ali Bauzipum. Okay. When do you want? On the
Lordship, 8, Tuesday, 8th of August. I am for the respondents in all three cases.
Okay.
Much obliged, Lordship.
For motion, item number 6.
Oh,
Now,
yes.
this, Lordship.
Steno would be required. Yes.
Lordship, may I be allowed to withdraw the present item, Lordship,
Okay.
with the liberty to file afresh?
Item number?
6, Lordship.
Item number 6.
6 and 7.
Heard Mr. What's that?
Locking form, Lordship.
Laknai from learned counsel for the petitioner who prays for allowing the petitioner to withdraw the instant interlocutory application with a liberty to file afresh if required. Also heard Mr.
My Lord, I'm appearing for S. Mary, State Council.
Mr. T. Fugo Form who P. Tipa Form who is appearing on behalf of Ms. S. Mary, learned Senior Government Counsel, who does not oppose the said prayer. Considering the submissions of learned counsel for both sides, the prayer is allowed. This interlocutory application is dismissed on withdrawal. With the liberty
To file afresh.
as sought for granted.
Much obliged.
Yes. Mr. Jamir. Yes.
Lordship, may I continue with the item number 31, Lordship?
Yes.
Lordship, I'm also relying on the decision rendered in
You have to furnish me a photocopy of WBC 92/.
Lordship.
Later on, you may furnish it after
After copy, Lordship.
Yes.
Lordship, read appeal 25 of 2022, Lordship.
This is. Yes, writ appeal 25.
25 of 2022, Lordship. Even in this case, the state has preferred an appeal against the decision of the learned single judge, Lordship. Now, even this appeal was also dismissed, Lordship. The relevant paragraphs are, Lordship, 5, 10, 11, 13, Lordship, 15 and 16, Lordship.
Yes.
This appeal was also disposed on the principle of applying the principle of Jagjeet Singh's case, Lordship, that the petitioners are also entitled to minimum of the regular pay scale, Lordship, as the regular employees are enjoying, Lordship. So the appeal preferred by the state was also dismissed by the judgment in order, Lordship.
Okay.
Now, Lordship, relying on the decisions, the authorities that I have placed before Lordship, Lord, my respectful submission before this Honorable Court is that I have made specific amendments in my read petition that I'm rendering similar duties and responsibilities as a sweeper with those of the regular employees. I have made specific and categorical statement in my read petition that has not been disputed. It has been admitted, in fact, by the state respondents, Lordship. Therefore, Lordship, I may be
And for the purpose of giving equal pay for equal work, you cannot discriminate between regular and temporary employees.
Lordship, exactly.
That is
Lordship. And also my additional prayer is, Lordship, I'm also seeking for errors, Lordship, in the case which I have referred, Lordship.
you have made prayer in your
Yes,
petition.
Lordship. I have made my prayer even in my petition, Lordship. However, in this case, Lordship, I have to be clear
Since which date you are claiming?
from the date of representation, Lordship.
Yes.
The facts are very clear, Lordship. As per the information furnished by the respondents, the regular sweeper is paid in a scale pay of, in terms of the ROP 2017, which is the latest ROP, Lordship. Therefore, my respectful submission is I should be entitled to be paid minimum scale pay of in terms of ROP 2017, Lordship, and also the arrears, Lordship, from the date of my representation, Lordship. That's my respectful submission, Lordship.
As regards areas, do you have any authority?
Lordship, yes, the authorities which I've just relied upon.
There
it has-
also area where
Yes, Lordship. It is also discussed about the areas, Lordship. Much obliged.
Yes, Mr. Fong.
May I please, Your Lordship? My Lord, here the petitioner is submitting that petitioner was appointed. Petitioner was appointed on 2003 and granted scale of pay as per the ROB to 1993. That is the claim, my Lord. Here, 1993 ROB has been superseded by 1999, and 1999 ROB is superseded by 2003, and after that, 2003 was superseded by 2010, and now the present the ROB 2017 is in the field, my Lord. So as per 2017, it says that those who are appointed on fixed pay or contingency work charge, they are not eligible.
Very
So, Your Lordship may kindly see in my affidavit in opposition. Affidavit in opposition, page number 5, Annexure A. Annexure A. Affidavit in opposition filed by the state, my Lord. Page number 5, Annexure A.
Yes.
Yes, Rule 2. Rule 2. May I read, Your Lordship?
Yes.
Applicability of the rules. Clause A. These rules shall apply to all regular employees appointed to service or post in connection with affairs of the state of Nagaland and which are under the rule-making power of the Governor of Nagaland. Clause B. These rules shall not be applicable to, number one, all categories of work charge employees, person paid out of contingency, person employed on contract, person re-employed in government service after retirement, and any other class or category of person whom the governor may, by order, specifically exclude from the operation of all or any provision contained in this rule. So, my lord, here the petitioner is still in temporary service. His service has not been regularized. So, as per 2017 ROB, the petitioner is not entitled. My lord, this is my first ground, my lord.
No, which clause you have read just now?
I'm relying on Rule 2, Clause P.
2B. Okay.
Rule 2, Clause P. Here it clearly says that all categories of work charge employees, these rules shall not applicable to. So until and unless the petitioner service has been regularized, under this rule, he is not entitled. So this ROP is meant only for the regular employees.
So otherwise he is getting salary as per ROP 2003.
No, 1993. As per his plan.
You are still getting
Yes. he's
as
still
per
getting
ROP
this.
of
Yes.
1993, Lord.
1993.
I'm getting only a salary of 5,280, Lord. In terms of 1983 ROP, Lord.
In 1993 ROB, these all categories were included. Even the work charge categories were given this benefit. But after superseded by 1999 ROB, 2003, 2010, and 2017, they are not eligible. So this is the first count, my lord.
Okay.
Secondly, my lord, there is office memorandum. Your lordship may kindly see in my affidavit of possession, page number 11, Annexure C. Page number 11, Annexure C. May I read, your lordship?
Yes.
Dated 24 July 2017, this office memorandum was issued by Commissioner Nagaland. Subject: matter relating to appointments made on the basis of casual or contingency, admissible pay and regularization thereof. In continuation to this office OM dated 19/7/2013 and later dated 02/03/2016, it has been found that application for grant of scale pay, service regularization of contingency, casual employees are still being forwarded by the concerned Deputy Commissioner despite repeated reminder not to forward such cases. Number one, it is hereby reiterated that these appointments were made without sanction post and therefore no application should be submitted for grant of scale pay in respect of any employees in this category. Regularization of service through district level recruitment board is admissible provided there is a sanction post vacancy and the employee has the prescribed qualification. Application for regularization of service outside this shall not be entertained by this office and therefore should not be forwarded. So, because of this letter, the concerned department cannot forward the matter relating to the requesting for granting of scale of pay. This OM is still in operation, madam.
But it appears to be against what has been laid down by Supreme Court.
Yes.
What the judgments.
But the petitioner has not challenged this OM. Secondly, the judgment which was relied by the petitioner has not set aside the ROP 2017 or this OM. So in absence of such direction, whether the respondent can consider the petitioner case in violation of this 2017 OM and this 2017 this OM, ROP 2017 and this OM. So in violation of this OM, the state respondent cannot consider. That is the stand, my lord. And thirdly, my lord, the petitioner is relying on the writ appeal, which was dismissed by the division bench. There, the facts of the case in these facts is very much different. In that writ petition, the petitioners, they were fixed, they were appointed on fixed and contingency. Here, the petitioner is enjoying scale of pay. And this, the writ appeal which the petitioner is relying are not applicable in this case, madam.
No, but the issue there also issue was equal pay for equal work.
Yes, my lord. Yes, lord. That was decided. However, my lord, regarding the equal pay for equal work, my lord, here, your lordship may appreciate that regarding equal pay for equal work, the petitioner should first establish that they are performing the same nature of duty similar to the regular employees.
Yes.
Yes, they have to establish.
There
Yes,
is-
they have made
It
the
is submitted
statement.
that they have established.
No,
their-
my lord, they have made the statement. Yes, they have made only the statement, but they show that this is the duty performed by the petitioner and this is the duty performed by the regular employees. That has not been established, my lord.
Okay.
So my prayer is, in violations of standing ROP 2017 and this OM dated 24/7/2017, the petitioner case could not be considered by the state government.
So your submission in nutshell is, as ROP 2017 itself excludes
Yes,
the
ma'am.
present petitioner.
Yes, ma'am.
Number two, the facts of the case relied upon by the petitioner are distinguishable.
Yeah.
Number three, that the petitioner has failed to show that he performs the same nature of work as those with whom he is claiming parity, that he has failed.
Yeah.
Okay. Any reply? Or you are done with?
Yes, that is my submission, my lord. That is my submission. Much obliged.
The lordship allows me, lordship, I'll just take 2 minutes, lordship.
Yes.
Lordship, with regard to the duties and responsibilities, lordship, I have made categorical statement in paragraph 5, 6, 7 in my writ petition, lordship. 5, 6 and 7 in my writ petition, lordship. Lordship knows this is a writ court, lordship. Cannot call for evidence, lordship, and have made categorical statements, lordship. And when the state respondents, they are file affidavit, at paragraph 7 of the affidavit, lordship, it is stated that the answering deponent offers no comments, lordship, which is admitted, lordship. I have categorical statement that I'm discharging similar duties and responsibilities and identical duties, lordship. Now that has not been disputed, in fact it has been admitted, lordship. Coming to the ROP 2017, lordship, it is a settled principle of law that are ruled framed under Article 309 of the Constitution cannot override
a precedent laid on under Article 141 of the Constitution, where a law declared by the Supreme Court is binding on all the courts in the country, Lord. Therefore, the impugned letter which is issued by the respondent, it has to be interfered and question set aside, Lordship. And coming to the Lordship, whether they are on scale of pay or fixed pay, Lordship, Supreme Court is very clear, Lordship. It is a principle of equal pay for equal work, Lordship. And it has not relied upon whether ROP 1993 is existing or 2017 existing, Lordship. The principle will apply, Lordship.
My Lord, little clarification, my Lord. If they are aggrieved by ROP 2017, saying that
your submission is they should have challenged the
yes,
ROP.
they should have challenged, and it has not been set aside, still in operation. That is the clarification.
Okay, I'm reserving the judgment.
Lordship. Much obliged, Lordship.
Much obliged.
For hearing item number 49.
May I please, Your Lordship? The contention of the petitioner in this case is that though vacancy was available for the post of deputy director, his case for promotion was not considered in time. Hence, he had retired before getting promotion, therefore, has approached this honorable court for grant of notional promotion after retirement. The main contention is that DPC was not held in time and has missed his promotion. The petitioner was appointed to the post of Extension Officer Class 3, non-gazetted in the Department of Industries and Commerce.
Item number 31. Heard Mr. Muaz Zamir, learned counsel for the petitioner. Also heard Mr. E. Tiba Form, learned senior government advocate. Hearing concluded, judgment reserved. Yes, please.
Yes, Your Lordship. The petitioner was appointed to the post of Extension Officer Class 3 non-gazetted Industries and Commerce on 9 March 1981 through NPSC, Nagaland Public Service Commission. Then he was promoted to Functional Manager Class 1 gazetted on 1st June 1993 by order number IDA 4481, and he has retired from Functional Manager on 31st October 2000.
Petitioner retired on?
He is retired from service on 31st October 2009.
As? Retired as?
Retired as Functional Manager. Now the main contention of the petitioner is that three vacancies were available since 2007.
Okay.
3 vacancies were available since 2007. Retirement 1 post was vacancy created by Mr. Chura Lohe, Deputy Director, and retirement by Mr. Fusenzo Angami, MD, dated 31/10/2007.
Functional manager, what would have been your next promotion post?
Deputy Director.
Deputy Director.
Yes, Deputy Director, General Manager, or there are different categories with equivalent payment.
Okay.
And so 3 posts was available. And finally, date of Honovi IA, Deputy Director, who expired on 29/5/2007. So from 2007 till 2009, before he retired, three posts was available. Then with the coming of Nagaland Retirement from Public Employment, Second Amendment Act 2009, dated 7 August 2009. The petitioner was made to retire. The return, page number 101. Yes, page number 101, annexure 4. That is the order of retirement. The petitioner was listed on page 103, serial number 11. That was his. Serial number 11. Before retirement, the petitioner made several representation for promotion to the post of Deputy Director, given in page number 142, annexure H. Page number 142, annexure H, and page number 147, annexure J. Those are his representation. Consequently, the Joint Director, who was the then Joint Director, forwarded his representation of the petitioner on 25/11/2008, page 148, annexure J1. Page 148.
What is this J1?
It's 148, annexure J1.
And this is forwarding letter.
Yes, forwarding. Forwarding of representation in respect of Sri Sekedo, Kyosho Functional Manager, for promotion to the post of DDI, General Manager, and Restoration Office, Seniority List 0. And consequently, J2. J2, page 149, that is the forwarding
No,
letter.
what is this forwarding letter?
Yes.
It says that
proposal for
148.
Pardon, sir?
You are reading 148.
Yes.
What is 148?
Forwarding of representation.
But it speaks something else.
For the promotion of DDI or General Manager.
That is at 149 only. Not 148.
There is two forwarding letter. two. One is J1 and one is J2.
J1 speaks that some letter has been, could not be traced out. That is the content of J1. Read J1.
J1. Your Mr. Letter.
There is some.
Your Lordship, this is the amended petition. Whether you are reading the amended petition in the
There are two petitions.
sorry, Your Lordship.
There are two set of papers, index serial number 1, index serial number 2.
Yes, yes.
Which one you are referring to?
Yes, then please come to G2. G2 is the letter date.
149.
Yes, 149.
Forwarding of your representation to the commissioner.
Yes,
Thereafter,
yes. In this one, this case for promotion has already been proposed to by this office letter, even number 29 May 2007, along with the SCR for the last trade against the vacancy caused by the death of Sri Honovi IA Deputy Director, General Manager, NIDC Dimapur. Yes. After this forwarding, there is no response from the department, and then he retired. In the meanwhile, he has given so many representation where the petitioner is aggrieved of letter dated 16/12/2015 in annexure L 181, page 181.
so what is this?
Page 181. L in the point number 2, where it is stated that in the light of the above, it is conveyed that the representation submitted by Sri Sigito Yusuf, functional manager, retired, for promotion as of cannot be entertained. That was the letter issued where the petitioner is aggrieved for.
What was the ground given for rejection of your representation? What ground was mentioned? Why it was rejected?
Yes, in the first part, it is mentioned the Department of Personnel and Training Office memorandum dated 12/10/1998. In the first part, retired employees who were within the zone of consideration for promotion in the relevant year but were not actually in service when the DPC is being held against a particular year may also be included in the panel. The retired employees, however, will have no right for actual promotion, as their inclusion in the panel is being done for the sole purpose of identifying the correct zone of consideration for the year concerned. And the third point, Fundamental Rule 17(1), an extract of which is enclosed as Annexure A, stipulated as an official shall begin to draw the pay and allowance to the post within the effect from the day when he actually assumes the duties of that post. As such, it would be an act of irregularity to retrospectively promote the retiree, Sri Segido Yosef, to the next higher grade of post as Deputy Director and grant of pension benefits attached thereof when the official had not actually held or performed duties of the aforementioned post. That was the ground. The fundamental rule which they have sought is Annexure L1, page 182. The Rule 17.1 says that, subject to any exemption specifically made in this rule and to the provision of substitute, an officer shall begin to draw the pay and allowance attached to his tenure of a post with effect from the date when he assumes the duties of that post and shall cease to draw the same as soon as he is discharged those duties. And letter dated 16 April 2021, annexed in Annexure B, page 104. That is where the review of DPC 1992 and consideration thereof in respect of Sri Segido Yosef in the light of judgment order dated 27/08/2020 passed by the Nagaland Lokayukta in case number ANLP. Conveyed that the government does not find merit in setting up DPC to review the matter. That is another letter where the petitioner is aggrieved. And Annexure B1, page 105, the next page. That is.
No, what this letter is, Lokayukta letter. What this Annexure B is, 104.
This is, they have written that the petitioner before coming to this honorable court has filed a case before the Nagana Lokayukta, where the Lokayukta has directed to review the DPC of his previous promotion, that is functional to the post of functional manager in the year 1992.
Okay.
Now he is seeking for promotion to the post of deputy director, but the order came out in such a way that to review the 1992.
No, I'm not clear. You are holding the post of functional manager.
Yes, and seeking for the post of deputy director. But
prior to being appointed as functional manager, you were holding post of
functional manager.
Now, before that?
Before that, extension officer.
Extension officer. When you approached Lokayukta?
After retirement.
You approached Lokayukta after retirement?
Yes.
Seeking what remedy?
You are seeking for promotion to the post of deputy director.
Same relief you?
Yes. This is the same relief, but the order came out and stated out that DPC 1992 should be reviewed.
Why DPC 92 DPC is relevant? Because 92 DPC is with regard to
functional,
where you were promoted as functional.
Yes, already promoted.
That by that order you were not aggrieved.
Yes. So, because holding the same post and all the benefits were given, he has been holding in the post of functional manager for 16 years. So he is asking where the industries and service will gives the provision that if a functional manager is serving for 5 years, that he shall be eligible to promotion to the post of deputy director. But he has been holding for 16 years in that very same post. And
No, that is clear. I'm not clear about the order which was passed by Lokayukta. You prayed for same relief before Lokayukta.
Yes.
Which Upalokayukta.
Yes.
Which you are praying before this court.
Yes.
That is, you approached before Lokayukta after your retirement.
Yes.
Seeking notional promotion to the
Yes.
post of deputy director.
Yes.
Then how 1993 DPC, 1992 DPC becomes relevant?
I don't know how it came
No,
out.
no, you have gone through the order.
Yes, I have gone through, but as per the order is annexed with the petition, you may please.
Otherwise, you are not challenging, you are not
And
before.
not challenging, not challenging.
Okay, you continue your submission.
Okay.
Your main case is
Promotion.
that you were eligible for promotion in the year 2007
Yes.
or before that.
Eligibility has been arrested before that, but the vacancy were not
Vacancy
only.
in 2007.
Yes.
Between 2007 to 2009,
Yes.
there were 3 vacancies.
Yes.
In spite of that, the respondent authorities did not hold
Yes.
DPC.
Yes.
Because of which you were deprived of your promotion and
Yes.
you have to retire without getting promotion.
Yes.
Now you have come
Yes.
for
Notional promotion.
notional promotion.
Yes. Your Lordship,
And you are also challenging the rejection of your representation.
yes,
Are you challenging
yes,
that
because the
annexure L,
annexure
L,
L,
where they cited Rule 17(1) of fundamental rules
yes,
for rejecting your
Yeah.
representation?
that is what the respondent has claimed to be applied against the petitioner.
When did you retire?
31st October 2009.
When did you approach this court? In 21.
Yes,
Why so late?
Your Lordship.
After how many years you approached this court?
It's 12.
12 years.
Yes,
So was not there latches on your part?
Your Lordship. During the petitioner service, there are so many representation has been going on. There are so many programs going with his service. Still, he tried to approach the court, but what happened is that he was prevented by the senior, his authority, senior officers, saying that if you approach the court, your service may not be favorable for you.
No, but
And
after retirement?
No, after retirement is that after retirement now what he have applied all is in vain, so he left. But in the year 2019, the government of Nagaland has published in the newspaper that the national promotion will be given to the retired person who are exonerated from the disciplinary proceedings. So, based on that, he filed this complaint before the Lokayata, then he applied this before this court. Based on that rule, the rule has been annexure MA.
At page?
page 187.
Because of this office memorandum you came.
Yes. Or else the petitioner has already gave up. He won't be filing if there had not been this notification. In page 186, the newspaper in 184 annexure M. That is the Nagaland page. Page 184 annexure M. Right below, there is government notifies on promotion after retirement. That is the publication given by the newspaper. And the memorandum is Annex H, MA, page 187. Promotion of government servant found fit by review DPC after retirement, procedure and guidelines to be followed. In Rule 2.4, the national promotion, national pay fixation and revision of pension shall be further subject to actual increase of pension shall be given only from the date of approval of review panel and by the competent authority. In 2, a government servant who is not recommended in the panel by the original or supplementary DPC but later on is recommended in the panel by a review DPC but has since retired may be given the benefit of national promotion with effect from the date of promotion of his immediate junior in review of panel and fixation of national pay subject to fulfillment of the following condition.
Now, are you basing your claim on
Yes.
this annexure MA?
Yes. Yes. Your Lordship, say, you may please come to annexure B1, page 102. 105, page 105, annexure B1. There, the respondent authority has given in point number 7, the last paragraph, point number 7, as per the record, denial of promotion to Sekedo Yoshe in 1992 was due to application of the Nagaland Service Discipline and Rules 1967 and memorandum issued by the Home Department, Appointment A Branch, Government of Nagaland, 9 June 1996. Here, what happened is that in 1992, the petitioner was not given promotion based on ACR remarks, saying that he is unfit for promotion. But while this letter states that action has been taken under Nagaland Service Discipline Appeals Rule 1967, but in reality, they did not conduct any disciplinary proceedings against the petitioner. No notice was served, no charge sheet was served, no fair hearing was given, no communication of his denial of promotion was given to the petitioner officially. There is no any such record. Now they are saying that disciplinary action has been taken, for which the petitioner now is claiming that his case may be considered under the said rule, which was notified in the in annexure MA.
But annexure MA speaks that if you were considered for promotion,
yes,
and you were in the panel, and before giving actual promotion you are already retired,
yes,
then under certain circumstances benefit may given.
yes,
But in your case you were not at all considered for promotion by DPC.
yes.
So whether annexure MA is applicable to you?
Yes, I believe so.
How? Where is which clause is applicable to you?
Because the department during the promotion also, it is an DPC was never held. That is another problem with the respondent department. DPC was never held. In the case of superseding the petitioner was done through a different committee, which was their case was forwarded to the minister concerned for promotion.
No, you are mixing up everything. You have to be very clear. Otherwise, I will not understand. What I have understood is you were promoted from the post of in what post you were having before becoming functional manager? Extension officer.
Yes.
To the functional manager.
Yes, to the functional manager.
Then during your tenure as functional manager,
yes,
you have the 3 posts were vacant of deputy director.
Yes,
but no DPC was held in between 2007 to 2009.
Yes, no DPC was held.
And therefore you could not get the benefit of getting considered for the promotion, and therefore promotion was not given to you.
Yes,
and
yes.
you retired in the year 2009.
Yes.
This is your simple submission. But
Yes.
later on many things are coming up.
Yes, yes.
That you also approached to Lokayukta.
Yes.
That you approached Lokayukta only because of publication of a notification by the government that retired people will be given promotion.
Yes, yes.
Then again you have submitted that earlier promotion was denied to you because of some departmental proceeding.
Yes.
So now on what basis what is the basis of your claiming post-retire?
Again, there is a
No, Mr.
Next, Zassi Tole.
Mr. Jassi Sole.
Yes. There is another rule under where I am claiming for the same.
No, you very clearly you submit point-wise. What is the basis of your claim? Facts are you retired in the year 2009.
Yes.
And posts were available since 2007 to 3 posts were available.
Yes.
Now you have come before the court in the year 2021.
Yes.
First you have to explain why you approached the court so lately. And thereafter, what is the basis of your claim? On what basis you are claiming post-retirement promotion?
Before till the publication of that notification in Backlog.
In 2018.
Yes. Till that one, the petitioner thinks that his case is over, so he did not approach after since retirement he did not approach. But only after the publication of this, he realized that his case may be considered under the notification, where the government of Nagaland has also implemented.
Okay.
And there is, under Annexure O, there is one rule, page 234. Page 234 and 35. In 35, frequency of departmental promotion committee meetings. Here, under this one, Rule 3.1, the DPC should be convened at regular annual intervals to draw the panels which could be utilized on making promotion against a vacancy occurring during the course of a year. For this purpose, it is essential for the concerned appointing authorities to initiate action to fill up the existing as well as the anticipated vacancies well in advance of the expiry of the previous panel by collecting relevant documents. The ministries and departments should lie down a time schedule for holding DPC and controls under control, and after laying down such a schedule, the same should be monitored by making one of the officers responsible for keeping a watch over the various cadre authorities to ensure that they are held regularly. Holding of DPC meeting need not be delayed or postponed on the ground that the
But then you should have sought the relief of regular DPC under this rule
yes,
much earlier. That DPC has not been convened annually
yes, no,
as required
Uh,
by
as-
this rule.
yes,
But you are approaching the court after so many years
yes,
for holding
the DPC,
DPC.
yes. And I've also relied a case,
Facts are over, or anything else is remaining.
yes. If they're not different.
No, you complete your submission. Thereafter, I may put queries.
Okay. The OM dated 15 November 2018, promotion of wrong service was also implemented by the government of Nagaland and is given in Annexure MA.
Yes. Annexure MA is a Government of India notification.
Yes.
It is followed by Government of Nagaland also. Is it followed?
Yes, in Annexure MB. In Annexure MB, the government of Nagaland notification is given in Annexure MB. Page 189.
Yes.
Yes. That is the submission, and I have relied this one case, RK Kawatra versus Ministry of Defense in Annexure
What is the citation?
yes, Q3, page 268, yes, page 273, paragraph 23, where it was stated that which DPC were not held in time in the last line. DPC were not.
Just a minute. You have annexed that judgment in the writ petition itself, no? Okay. 273.
Page 273,
Yes.
paragraph 23. In paragraph 21, it says that the issue of delay in holding DPC has not been clarified satisfactorily by the respondent, neither in the pleading nor even during the final hearing. That is one. And 23, it says that to conclude, after considering the pros and cons, the balance clearly tilts in favor of the applicant. This is a case where it appears the respondent department did not apply principle of due diligence in the matter of promotion at the level of
This is a judgment of which court?
Supreme Court. Oh, sorry, it is CAT, Administrative Government.
Okay.
Central Administrative Tribunal, Jodhpur Bench. And DPC,
What precedentiary value it has?
it has the same ground that the DPC was
No,
not
no.
held in time.
Whether it has a persuasive value?
May be referred, but may not have the persuasive value.
Okay. Okay.
I'm making for the reference only, so that this honorable court may. But the main contention was similar to the instant case was citing, saying that this DPC was not held in time, so DPC should be DPC should consider the promotion of the applicant that was the directive given by this Central Administrative Tribunal.
Yes.
Yes, again in the case of Brigadier Nalin Kumar Bashia versus Union of India and others, this is Supreme Court of India, page 275 to 281. I would like to read out one para in page 280, point number 20, where it states that there is no presumption that a decision taken by person occupying high post is valid. All power vested in these authorities has to be discharged in accordance with the principle laid down by the Constitution and other statutes or rules, regulations governing the field. The judicial scrutiny of a decision does not depend on the rank or position held by the decision maker. So I'm to say that now whatever the blame has been given to the petitioner during his promotion in the initial stage of functional manager and later on, and DPC was not held in time, and now they are saying that it is not possible. So as per this judgment, what I feel is that this honorable court has the discretionary power where to do justice to the petitioner. And that is my humble prayer, to consider motion of promotion.
Now, what relief you are seeking?
I'm seeking for motion of promotion.
No, what direction this court should give? To whom? To whole DPC?
To the respondents.
Yes.
To whole DPC also, or even to allow his representation made for the promotion or motion of promotion.
Without DPC? No, be clear in your submissions.
DPC might be held because as per the procedure, DPC should be held. And in their service rule also, they have clearly mentioned that DPC should be held annually. It is in their service rule. The service rule annually they should have, but they did not have DPC during the service time of the petitioner. So what the petitioner feels is that for his case only DPC may not be also held. But as per the provision, as per the service rule, DPC should be held. So if this honorable court could direct the DPC to be held and consider for motion of promotion, then that will
No, that is your submission that
yes.
to direct convening of special DPC for considering national promotion, prayer for national promotion of the
Yes.
present petitioner.
Yes.
Okay.
That's all.
Yes.
Please, Lordship. Lordship, here the petitioner he has wrongly clubbed two issues together. He is asking for national promotion to the post of deputy director, and the other one is for review DPC for 1992 for the post of functional manager. So, Your Lordship, for the notional promotion.
Why that second prayer is made? Because second prayer review DPC, why?
There was no DPC at all. There was no, when there is an initial DPC, then the review DPC may arise. But when there is no initial DPC, the question of review DPC does not arise. So Your Lordship, he is approaching this court for notional promotion to the post of Deputy Director after a lapse of 12 years. Then he is approaching this court asking for review DPC in the year 1992. That is after a lapse of 29 years. So Your Lordship, the petition is totally misconceived, and it is and there is a gross delay and laches on the part of the petitioner. Petitioner has been saying that he has been repeatedly filing representation, but Your Lordship knows that numerous filing of representation does not arrest the time, Your Lordship. So Your Lordship, in the year 1992, when the promotion to the post of functional manager arose, the petitioner could not be considered because he was placed under suspension because of the Nagaland discipline and abuse rules. So his immediate junior, Wan Toshi Ao, Wan Otem Ao, was given promotion, Your Lordship. So here, Your Lordship, in page 145 of the writ petition, this is the office memorandum. Memorandum dated 9/6/1966.
What is this?
So Your Lordship may come to point 3, clause 2.
Yes.
Where promotions are made on the basis of seniority, subject to the rejection of the unfit, the seniority of person considered fit for promotion at the same time shall be the same as the relative seniority in the lower grade from which they are promoted. Then the next line, Your Lordship, this is crucial to our case. In case a person is considered as unfit for promotion at one time and is superseded by a junior, such a person shall not, if he is subsequently found suitable and promoted, taken seniority in the higher grade over his juniors who had superseded him. So, Your Lordship, this OM clearly says that when at the point of time when he is unfit to be considered for promotion, and when his immediate junior has been promoted, and later he has been promoted, he could not
Claim
seek seniority. So, Your Lordship, the petitioner, he was given promotion in the year 93, and his immediate junior was given promotion in the year 1992. So he never challenged this OM also, he never challenged the promotion of his junior all along. Only before this court, after a lapse of 29 years, he is raising all these issues. So Your Lordship, the delay and lectures is hit, so it cannot be entertained. Then Your Lordship, with regard to the OEMs which the petitioners are relying on, those OEMs are not at all applicable to the petitioners, Your Lordship. Because those OEMs, Your Lordship, if Your Lordship sees that page 187, this is the Ministry of PNRR, Department of Government of India, which has been adopted by the Nagaland government in page 189. But page 187, Your Lordship, it's very clear at 2. At point 2, a government servant who is not recommended in the panel by the original supplementary DPC, but later on is recommended in the panel by a review DPC, but has since retired, may be given the benefit of notional promotion with effect from the date of promotion of his immediate junior, in the review panel and fixation of notional pay subject to the fulfillment of the following condition. Number one, that the officer who is immediate junior to the retired government servant assume charge of the higher post on or before the date of superannuation of the retired government servant. So, Your Lordship, this is never applicable to the petitioner, because at the time of the petitioner's retirement, there was no court proceeding, nor there was any disciplinary proceeding against the petitioner. So this OEM talks about to a person where there is a court proceeding pending and where there is a disciplinary proceeding pending. And Your Lordship, when the vacancy arose, the petitioners and his immediate seniors were sent to the government for consideration for the post of promotion to the post of deputy director. But during that point of time, the Nagaland retirement from service public employment came into effect. Your Lordship may come to my affidavit in opposition, page 5. Page 5, para 8.3.
Yes.
However, before the matter regarding promotion to the post of deputy director could come to fruition, both the petitioner as well as Sri Otem Saau were released from service on retirement by the order dated 13/9/2009 in terms of the Nagaland Retirement for Public Employment Second Amendment Act 2009. In the list of retired employees enclosed therewith, the petitioner appears as serial number 11 and Sri Otem Saau appears at serial number 7. So, Your Lordship, where is the question of holding, not giving the petitioner the promotion? It is because of this law. It came into effect. For that reason, they were made to retire. Then, Your Lordship,
What this law says?
it says a person should be in service either 35 years length of service or 60 years of age. So, the petitioner, he retires by 30.
Why this was brought? Why this rule was brought? Whether service rules?
No, Your Lordship, this is the Nagaland Retirement for Public Employment Act. Yes. So the petitioner, he retired after serving 38 years in the office. But as per this act, a person will retire from 35 years of length of service or either 60 years of age.
Whichever is earlier.
Whichever is earlier, Lordship. So, Your Lordship may come to page 8.4. Nonetheless, it is stated that both the petitioner as well as Sri Otem Saau were granted time-bound scale in the scale of pay of deputy director as per ROP revision of Pen 1999, that is RP such and such. Sri Otem Saau was granted time-bound scale by such and such. As such, the pension have been adjusted accordingly in that scale. So here, Your Lordship, though they were not given the promotion, they were given the time-bound scale in the scale pay of deputy director.
Okay.
And the scale pension has been adjusted according to that scale. So where is the question of a grief by the petitioner, Lordship? Then Your Lordship may come to page 7, para 11.
Yes.
Yes, page 7, para 11. That with regard to the statement made in such and such, the deponent stated that both the central government OEM dated 14/9/1992 and 25/01/2016 are not relevant for the purpose of this petition. Both the said OEMs refer to promotion of government servant against whom disciplinary or court proceedings were pending or whose conduct was under investigation. Such is not the position in the instant case, hence all other allegations are denied. Then Lordship may come to the next page, para 12.1. In the instant case, the immediate junior of the petitioner in the post of functional manager, that is Sri D. Lontok Home, was not promoted to the post of the next higher grade, that is Deputy Director, on or before the date of superannuation of the petitioner, as prescribed by Clause 2.1 of the OM dated 15/11/2018. Instead, promotion was granted to Sri D. Lontok Pom after the retirement of the petitioner via notification dated 19/8/2011, along with other similarly situated employees. Then 12.2. In addition, Clause 2 of the OM dated 15/11/2018 envisages a situation where a government servant was not recommended in the first instance by the DPC, but was later recommended by a review DPC. But the government servant has retired by the time the review DPC made its recommendation. Whereas in the case at hand, as already adverted to above at paragraph 8.3, DPC could not be held for considering the petitioner case along with others for promotion to the post of Deputy Director prior to the retirement of the petitioner. As such, in the absence of holding the initial DPC, the question of holding a review DPC does not arise. So, Your Lordship, it's very clear that when there is no initial DPC, the question of review DPC does not arise. And now challenging the seniority list of 1992 is a time bar. And even for asking for notional promotion is also time bar. And the petitioner has already been granted time bounds of scale in the scale pay of Deputy Director. So there is
So it's not aggrieved.
Yes, everything has been adjusted. Then Your Lordship will come to page, these are the impugn order which the petitioners are impugning in this writ petition, page 104. Page 104 of the writ petition. Dated 16 April 2021, letter written to the petitioner, subject, review of DPC 1992 and consideration thereof in respect of Sheikh Edo Yosa in light of judgment and order passed by the Nagaland Local Authority. I am directed to refer to your letter dated such and such on the subject cited above, and to state that the matter has been examined in light of judgment order dated passed by the Nagaland Local Authority in case number such and such, and to convey that the government does not find merit in setting up DPC to review the matter. Directorate of Industries and Commerce clarification on the matter is also enclosed herewith for your perusal. Then, Your Lordship, the next page, this is the clarification given from the director. This is 11 March 2021.
Yes.
Page 105. With reference to your letter such and such, and in continuation of this office letter of such and such, I have the honor to state that, number one, the issue dates back to 1992, when Sri Otem Saar, Extension Officer, was given promotion to Functional Manager, ahead of Sri Sheikh Edu Yosa, who is senior to the former as per the NPSC merit list. Number two, the out-of-term promotion was given to Sri Otem Saar, Extension Officer, on the decision of the government, which is clearly reflected in the enclosed note sheet dated such and such. 3. Later in 1993, Sri Sheikh Edu Yosa, Extension Officer, was also promoted to Functional Manager. Number 4. In the course of time, both Otem Saar, Functional Manager, and Sri Sheikh Edu Yosa, Functional Manager, had applied for promotion to the post of Deputy Director General Manager against the vacancy caused by the retirement of Sri Ponivi Ayer. However, before the government could initiate any action against the proposal for promotion, the Nagaland Public Employment Second Amendment Act 2009 came into force, by which both Sri Otem Saar, Functional Manager, and Sri Sheikh Edu Yosa, Functional Manager, were released from service on completion of 36 years and 37 years respectively. Number 5. Time-bound scale of pay was granted to Sri Sheikh Edu Yosa, Functional Manager, on his personal request and not imposed. 6. Both Sri Otem Saar and Sri Sheikh Edu Yosa were given promotion on officiating basis and not through departmental promotion committee. Therefore, the question of reviewing DPC does not arise. 7. As per the report, denial of promotion to Sri Sheikh Edu in 1992 was due to the application of the Nagaland Services Discipline and Appeal Rules 1967 and memorandum issued by the Home Department appointment such and such. In the light of the above facts, the department do not find merit to forward proposal for review of DPC 1992 in respect of Sri Sheikh Edoyo's functional manager. Then, Your Lordship, the last impugned order, that is at page 181, which is a letter written to the petitioner. Page 181.
Yes.
So, Your Lordship, this is a letter dated 16/12/2015. I am directed to refer to your representation dated 26/3/2015 and to say that the matter has been forwarded to the PNR department and duly examined and observations are made as under. 1. The Department of Personnel and Training Office Memorandum such and such states as follows. Retired employees who were within the zone of consideration for promotion in a relevant year but were not actually in service when the DPC is being held against that particular year may also be included in the panel. The retired employees, however, will have no right for actual promotion as their inclusion in the panel is being done for the sole purpose of identifying the correct zone of consideration for the year concerned. 2. It is hence abundantly clear from the above that promotions are to be sanctioned only to persons who are actually available in service. 3. Further fundamental rules 17.1, an extract of which is enclosed as Annexure A, stipulates that an official shall begin to draw the pay and allowances of a post with effect from the date when he actually assumed duties of that post. Number 4. As such, it will be an act of irregularity to retrospectively promote the retiree Sri Sheikh Edoyosa to the next higher grade of post as Deputy Director and run pension benefit attached thereof when the official had not actually held or performed duties of the aforementioned post. In the light of the above, it is conveyed that the representation submitted by Sri Sheikh Edoyosa, functional manager for promotion as sought for, cannot be entertained. So, Your Lordship, all this, all along, Your Lordship, only after his retirement he is making representation to the government. If at all he feels that he is aggrieved, he should have represented within the time, Your Lordship. But all these representations or his grievances are now time barred, Your Lordship. And there is no illegality, there is no arbitrariness or discrimination on the part of the respondents, Your Lordship. When there is no initial DPC, there cannot be review DPC. So, Your Lordship, that is one of my ground. And the other one is that the petitioner has not established his case to invoke the jurisdiction of this honorable court. So, Your Lordship, my prayer is that the writ petition need to be dismissed, Your Lordship. That's my humble submission.
Please, Your Lordship. Your Lordship, with regard to the disciplinary action as stated in the letter dated 11 March 2021 B1, that says that during his denial of promotion in functional manager was done through the application of Nagaland Services Discipline and Appeals Rules. Your Lordship, may please come to page 52 of the writ petition, where may please read page 52, para 2. That the respondent number 3, White Letter such and such, 11 has stated that the denial of promotion to the petitioner 1992 was due to application of Nagaland Service Rule 1967 and memorandum issued by the Home Department Appointment Branch dated 1996. Whereas the petitioner submit that the respondent number 3 have never followed the aforementioned service rule. That is, as per section 9 of Nagaland Service Discipline and Appeals Rule 1967 issued by the Government of Nagaland, Department of Personnel and Administrative Reform, Nagaland, Kohima. The rules clearly stated that without prejudice to the provision of Public Servant Inquiry Act 1850, no order imposing on government servant of any penalties specified in Rule 7 shall be passed except an inquiry held as far as may be in manner hereinafter provided. the service rule has been annexed here and page number 201.
No, but you have not challenged the denial of your promotion in the year 1992 till filing of this writ petition.
Yes.
Your Lordship. So after a year of 29 years, he is raising all these issues. So all these are time barred, Your Lordship, and there is no explanation given by the petitioner also.
During that time, if they have given a formal letter acknowledging the petitioner that your denial of promotion was undertaken under this rule, had it been done, then the petition might have rise. But during those days, it was never done.
But you knew that you were denied promotion.
Yes, he made several representations.
Your junior was.
Yes, he made representation to his superior officers, but not to the court.
Okay.
As in the opening paragraph, I've already stated that he was scared that if he filed a suit against his superior in the court, his promotion or his case may be hindered. So with that presumption, he didn't approach the court. If there is any formal letter, and even and even the DPC was not held, so the question of review or whatever may be, DPC was not conducted in any procedure at any point of time. It was never done. So that is why the problem arises, why he has been denied of his promotion. Had it been there, this problem may not be arise. And for the negligence of the respondent authority, the petitioner has been victimized. He has to serve the post for 16 years, where the eligibility criteria was given for 5 years. And the time-bound scale is for a temporary basis. It cannot be matched or it cannot be equated with the promotion or with the permanent post of payoff scale.
Okay.
Therefore, for the negligence and non-responsive of this, for not following the service or the procedures given by the government of Nagaland, as well as the service rule, the case of the petitioner may be please be considered. That is my humble submission.
What is this 14/12/11 representation in your prayer number 3? Prayer number 3. Before retirement, you.
Lordship, it's page 147.
147.
It's page 147.
This is regarding non-holding of DPC, or what was the relief sought for?
So, Your Lordship, this is his prayer for promotion to the post of Deputy Director. So, when the government is taking action to, in the process to promote them, the Nagaland employment
came into being.
Came into force, so they have to retire. So it could not be materialized. And his immediate junior was given promotion only in the year 2011. He retired in 2009, and his immediate junior was given promotion only in
because he still have some service left.
Yes.
immediate junior.
Yes, so that is, I have annexed the officiating promotion in my page 21 of my affidavit in opposition. His immediate junior, Lontok Pong, was given officiating promotion on 19 August 2011.
Okay. Done. Finish.
The vacancy was available, whatever his junior may be promoted in the year 2012, but still the vacancy was available. So it is the responsibility of the government to seek DPC or make arrangement for the available or eligible candidates for promotion, and that is the responsibility. So the negligence of the responsibilities cannot be made liable to the petitioner.
Heard Mr. Zasid Soleh, learned counsel for the petitioner. Also heard Ms. V. Shokre, learned additional advocate general. Hearing concluded, judgment reserved.
For hearing, item number 60.
Yes, what is this?
May it please, Your Lordship. Lordship, before I state my grievances, I would like to briefly state the facts. Now, Lordship, the petitioner is the owner of a plot of land located at this Joboten colony, Bandari town. And then that allocation was given by the government of Nagaland, that Bandari division. Why? As per the site permit number 38, dated 16 October 1978. Since then, the petitioner is occupying the land. And then he has developed a permanent structure, his residence, this and that. Several development has been developed by the petitioner. Now, Lordship, what happened is that sometime in the year, Lordship, my representation is the first representation. Why my first representation? That on 4/8/2021, that is my paragraph number 3, Lordship. Some 4 intruders, Lordship, they have encroached my land. And then, more particularly, Lordship, a person by name Shui Monchomo Beton.
Just a minute.
Lordship.
Paragraph?
Paragraph 3 of my petition, my petition. How I had made the representation before the authority, stating my grievances, Lordship. So this is my first complaint letter, 6/8/2021. I have made this representation to the authority. Lordship, I'll make it the matter symbol in order to more clearly, Lordship. Now, Lordship, if you, Lordship, may kindly turn to my...
What is stated in para 3? Some intruders came into your...
Lordship. And then here, see, Lordship, may I take your Lordship to my annexure 4. Here I have simply explained how the encroachment was done. Page 19 of my petition, Lordship. This is annexure 4. Though it is a rough sketch, but how I have they have encroached my land. Now, Lordship, 19, page 19. Page 19 of my petition, Lordship. What is Lordship? See, Lordship, the old road closed. Earlier, the road was straight. But in order to make the approach road, stating that the required lane, they have made in a U-turn, encroaching my lane.
I have somewhere indicated through track diagram, Lordship. That is how it has encroachment lane. Earlier, the road was straight. And then due to the encroachment made by one person, I've given the name also, Monchano, they have diverted the road in a U shape, encroaching my lane. That is my allegation, Lordship.
Who diverted the road?
Lordship. The very person that I have said it in my paragraph, one Monchomo Bedont. He has occupied the earlier old road, and then because of that, they have given shelter to him, and then they have diverted the road by making in a U-turn, and then encroachment lane. So, on that consequences, Lordship, I have made a representation in a way of complaint to the authority. My first complaint letter, Lordship. That is, as I have stated, Annexure 2. Annexure 2 is my first complaint letter. Page 16. Page 16. Annexure 2. This is 6/8/2021. This is my first complaint letter, Lordship. Complaint for necessary action. Here I have stated that my land has been encroached by some person, so kindly take necessary action because I'm enjoying the land on the site permit issued by them. So I have made that representation. Now, Lordship, the matter is I want to make it better sense in a simple way. Despite of this complaint, no action was taken. So I have made 4 representations. After this, I have made 3 representations. Including this, it is 4. And then the last representation is the 4th representation as a reminder representation, that is, Lordship, page 22, Annexure 6.
Who encroached your lot?
Of course, the private parties, I'll come to that. But before that, I want to state the facts, Lordship.
Okay.
So, the last representation, despite of my earlier representation, despite of my 3 representation, they have not considered. They have sheltered the intruders, the encroachers. So I have made the last representation, that is page 22, Annexure 6 of my petition. This is the reminder of passing Mrs. Lordship, the last representation, page 22. This is the last representation, the 4th representation. In between there are 2 representations. Now, why I have written this to additional deputy commissioner Pandari is because it is a subdivision, comes under the head of this additional deputy commissioner. So I have made a representation before him, stating that reminder for passing necessary and befitting order for removal of and warranted construction of a portion of approach road at such and such colony. Now, Lordship, despite of my representation, they have not given any reply, notice, this and that. If at all, they require the land for public purpose, they should have given a prior notice, or a kind of a natural justice should be given to the petitioner. But no sort of notice or prior information was given to the petitioner. That is one. Now, second, Lordship,
who are the respondents in this case?
Respondent, Lordship, here is Chief Secretary, number 1, States, Commissioner, Deputy Commissioner, Additional Deputy Commissioner. 4 respondents. 4 respondents. Now, Lordship, see, despite of this representation, they have not given any reply or no disposal of my representation. But only after the institution of this writ petition, they have deputed some official by gold deposits to survey or see the area. I'll come to that. And then they have surveyed the land, and then they have found some observation, and then that was included in the reply of the state respondent. That I'll come to that. Now the matter is like this, Lordship. My grievance is that since I'm enjoying the land on the basis of the site permit issued by them, I found it correct that I should approach them stating all these grievances. But they have not disposed of my petition. And then instead, they have sent for site inspection after the institution of this. And I want to bring to the notice of this honorable court that when they have visited the site, they have seized my site permit. And then till now, it is not returned to me, Lordship. The authority, the Deputy Distribution Commissioner, who has deputed one official as to civil, who has inspected, and then he has seized the site permit, and till now it is in their custody. That is, I want to bring to the notice of the Honorable Court. Now, as per the reply, Lordship, they are saying that the site permit is temporary permit, and it can be taken by the government anytime if the department, if the government requires. Fine, Lordship, I agree with that. But since 1978, I enjoy the land. But so they should at least give a prior notice, a kind of information to me. But such kind of procedure of law were never followed in this present case. That is one. Now coming to the Lordship, that is their reply, that anytime they can take the land area since it is only a temporary permit. That is the condition. Second condition is that my area, as per the site permit, Lordship may kindly do the permit, the site permit, my annexure 1, and then type copies at page 15A. Page 15, Lordship.
Yes.
Lordship, type copy, more for more clarity, site permit, name Longshidang Yatan, say and such, issued permit number 38, 16/8/1978, Longshidang, that is the petitioner. And then now coming to Lordship, location, boundary, north, Ayamo site, east, Nala, south, Ripamo site, west, Nala. It is clearly indicated in this. Now coming to the reply, Lordship. Coming to the reply of the state respondent, here, the reply, page 9, annexure 2. This is the scope verification forwarding submitted by the department to the additional deputy commissioner. Their reply to the state respondent reply, annexure 2, page 9. And then I'm referring to the page 10. Page 10. The land boundary demarcation are as follows. North 149, south 149, east 80, west 80. The neighboring land pata holder, north Ayamo, south Ripamo Muzi, east Nala, west Nala. Why I'm saying this is, they went for scope verification, and then they have measured the area, and they have given the observation that my area is more than the area indicated in the site permit. Their observation.
Yes.
Their observation. Lordship, their boundary as indicated by them in their observation in the site permit is same. So maybe it was issued 1978, the site permit. Maybe it may be more than that. That I may not deny, the petitioner may not deny. But there is no alteration or modification on the site permit. Whatever the measurement may be, but the demarcation of the area is almost the same. Now, their condition is the site permit is a temporary permit. It can be acquired anytime. I agree with that, but no prior information, no natural justice. And then I'm occupying the land since long back. I have constructed permanent structure. So they should at least give me some notice. That was not done. Second, they are saying that the area is small. And then forcefully, only after the institution of the present petition, they have given this spot verification report without disclosing my grievances as stated in my representation. So, see, Lordship, I'm saying that even the site permit, which was possessed by me, that also copy was seized by them. Until now, they have not given that return back the site permit. So, Lordship, my humble submission is that till now my representation is not disclosed. So let my representation be considered. And for all fairness, Lordship, my humble prayer is that let the petitioner be present in the spot verification and authenticate the land, because this report and then observation was made in absence of the petitioner, Lordship. So I may be given an opportunity to justify my representation. So in a very brief way, Lordship, I have made several representations, 4 representations. Till now, they have not disclosed. Only after the institution of this, they are replying to my statement. So my humble submission is that let my representation be disposed of or considered.
But your main grievance is that some private parties encroach your land.
Lordship, Lordship, that is my course of action. And then see, since it's, as I stated, I'm enjoying on the, my basis of ownership is on the site permit. So I feel it correct that I should approach the authority stating all those grievances.
No, but you could have approached a civil court also.
Lordship,
if your possession was disturbed by a private party.
Lordship, see, Lordship, my site permit is there. So, since they are the competent authority who have issued the site permit.
What is site permit?
Site permit is a kind of allocation of land, government land, to the individual party.
What law is prevalent?
Lordship,
Assam Land and Revenue Regulation is applicable here.
Lordship, usually in this Nagaland, in Kohima, the authority, they are issuing land patta.
No. What is the governing law?
If it is a government land, on the requirement, on the request of the individual, the government may issue a site permit or a land patta.
No, that is how things are done.
Yes.
My query is, what law governs how to allocate land? Who to allocate land? Till what period a land allocation may be done? Who is the owner of the...
Lordship, in a district, deputy commissioner is the authority.
No, that is not my query. My query is regarding law. What is the land and revenue regulation? Is there any land and revenue regulation in Nagaland?
Yes, my lord. Land Regulation and Acquisition Act 2000. There is one.
How land is allocated to private parties by the... Who is owner of the land is not government, or whether government is having land?
Earlier, what it used to practice was, my lord, the land belonged to the private, and that private land will be acquired by the state. And
that I have understood.
Yes.
I want to know the
Lordship, the system. Yeah, of course. I'll come to that, Lordship. The system is that, see, deputy commissioner being the district authority, under him, we will the individual who wants the land, he will he will make application for allocation of land as a procedure of law. And then according on the satisfaction of the application, if it is available, the deputy commissioner will give the land in a way of issuing land patta or site permit.
Land pattas and site permits are same thing.
out there in this district subdivision, they are called by site permit. Because whereas it varies from district to district. In Mochong, it is residential permit. Here in Kohima, it is land bata. Earlier in Timabur, it was Chamapandi, but now they have converted to land bata. So likewise, this site permit is a permit allocation of land, because here, I'll read to at that portion. If your lordship can need to come to the annexure for more clarity, annexure 1 of the affidavit in opposition of the state.
No, my first query is, it appears to be a dispute relating to possession of land.
Now, on this issue of site permit, I become the owner of the land on this land.
Suppose you are the owner.
Lordship.
Somebody else tried to dispossess you, encroach your land without your leave, without your permission.
Lordship.
Then which court you will approach, civil court or a writ court?
Lordship, here for that dispossessed, here I have grievances of encroachment, and then I have stated, since being the additional deputy commissioner is the head of that subdivision, I have stated my grievances to the stating my grievances in a way of representation.
But whether you should approach the DC or civil court?
That is located in the main headquarters of Woka town, Lordship, means Oka district. And then mine Pandari is a subdivision. And then overall, this ATC is the overall administrative head of that division. So in that way, since I am under that jurisdiction, I have made a representation to him.
No, whether civil court is not there.
In that subdivision, no civil court, Lordship.
In Woka?
Woka is there, Lordship. So my humble submission, whether it be considered or not, since I have made a representation, my humble praise, let them dispose of my representation. And then my humble submission is that in all fairness, they are stating that in their statement, my area is more than as indicated in the land bata. Let my presence be acknowledged, Lordship. That is my humble prayer, Lordship. And then, Lordship, as I stated, for more clarity, on this basis, I become the owner of the land. So if you kindly turn to annexure 1 of this photo is more clear, page 7 of the affidavit in opposition. Permit number, Lordship, page 7, annexure 1 of the government Respondent affidavit in opposition. Permit number indicated 38, dated 16 October 1978. Name, this is the petitioner, son and second such. Now, the second paragraph is hereby temporarily allotted a plot of land in Pandari town area for residential trade business purpose. This is how the site permit was allocated to me, Lordship. So on this tent, by this tent, I have occupied the land. I have constructed several development. And then, moreover that, Lordship, the third condition of the state respondent, they have stated that the approach road was constructed for the interest of public way. That is also their condition. That is also their response. So, if at all, for the interest of the public requirement, then I should have given a kind of information on this. But no such practices was done. So my humble submission is that since till now my representation is still pending with them, not disposed of. So my humble submission that let the
What is the stand of the government?
My lord, I have only 2 ground here. First, the petition is liable to be dismissed on the ground of non-joinder of party, my lord. Here. Because in the complaint letter filed by the petitioner in the year 2021, the petitioner is alleging that some private person is encroaching his land. And in the writ petition, they have not met the party. Number one. Because since the petitioner is alleging that in the complaint letter, you must kindly see the complaint letter in his writ petition, page number 16.
Okay.
Yes.
If private persons are encroaching the land,
Yes. Here,
how the court would exercise its
Your
jurisdiction?
Lordship, my humble submission, as I stated earlier, since additional deputy commissioner is the administrative head of that district, overall head, I approached them by way of.
But ADC is not to decide land disputes. Land disputes are to be decided by civil courts.
Lordship, that is why, Lordship, my humble submission, since I have made an representation, let them dispose of my representation. On the non-satisfaction order, I can approach any court, either the appropriate court.
No, but whether this court issue a direction in exercise of writ jurisdiction, unless your writ is maintainable.
Lordship, as I stated, on the strength of that site permit, I'm enjoying the ownership. And then I have made the representation. Now I have made allegation of some intruders. I have stated all those before them.
Okay, let me hear Mr.
and
Fong.
my lord, and
Let him complete.
Lordship.
And
Yes.
my second ground, the first ground is that one, and the second ground is, my lord, in this complaint letter, since the petitioner submitted this complaint letter, that is on 6/8/2021, this spot verification was conducted by the head GB, my lord. Spot verification. Since the petitioner submitted before the additional ADC Pandari, ADC Pandari has directed the head GB to conduct spot verification. And the spot verification was conducted, and after completion, the head GB has submitted the report. Your Lordship may kindly see in my affidavit, page number 11. Page number 10 is not clear, so the type copy is at page number 11. Here, page number 11.
Yes.
Yes. Type copy. May I read it?
Yes.
To the additional Deputy Commissioner Bandari, Wokha, Nagaland. Subject: submission spot verification of the land belonging to Sri R. Lungsithang Yantan of Tehobokpun Colony, Bandari. Sir, with due respect, I have the honor to state before your esteemed authority that, sir, as endorsed by the authority, on 8/8/2021, Sri T. John Kikon, first grade DB, Tangmo Mozoi, grade 2 DB, have personally examined one spot document and searched available record of the land belonging to Sri R. Lungsithang Yantan Pata, permit number, depth measuring breadth 80 feet, length 80 feet. Whereas DB's Pandari had remeasured the length of R. Lungsithang Yantan, had found exact length 149 feet, breadth 80 feet, as 69 feet exact was found to be encroached government land by Sri R. Lungsithang Yantan. That, sir, our own approach road was found to be free from all encroachments. It was found that there was no road blocked by Sri Mochomo Baton, no encroachment, no new house constructed by Sri Mochomo Baton in the land of Sri R. Lungsithang Yantan. So, my lord, here it says that it is not the private person has encroached the land. It is the petitioner who have found the 60 feet exact found to be encroached government land. So, This affidavit in opposition filed by the state, and the petitioner is silent about this letter. Petitioner has not filed any reply to this or counter to this letter. So it is deemed to be admitted, my lord. It was conducted on 8/8/2021, spot verification. So my humble submission is, my lord, one is non-joinder of party, and secondly, not challenging the spot verification submitted by the authority. On these two grounds, the person with petition is liable to be dismissed, my lord.
Otherwise, regarding maintainability of writ petition, you have no objection.
Lordship,
Maintainability, the petitioner have not met the party, necessary party.
Lordship, as I stated, since additional commissioner is the administrative head, and then on the issue of the land site permit, I'm enjoying the ownership. So I feel it correct that I should approach them by
No.
oral representation.
No, that is not my query. My
And
query
then,
is,
Lordship,
in event of, suppose the land has been allocated to you by government by whatever means, you are possessing that land, private party encroaches that land, then where to approach? Whether you would go to the person who allocated the land or go to the redressal forums like civil courts, because which court to approach in event of a land dispute? Question of evidence would come.
Lordship, I have made a complaint to that. In my first complaint, that some private party has, of no doubt, I admit to that, encroaches, but I'm stated in my complaint that on the, despite of my representation, on the shoulder of the administrative authority, they are doing all those encroachment. That is why I have already made in my representation. And now, second, Lordship, this spot verification report, it was made known to the petitioner only after the institution of the writ petition. And then here they have, no doubt they have given extra, means more than they have indicated that I have encroached. Rather, I have encroached. stating that-
Disputed site is situated in which district?
Wokha district.
Wokha.
Yes, my lord.
Civil courts are there in Wokha.
Yes, my lord.
Of course, Lordship.
They are.
Lordship. So, Lordship, my way of pleading before this honorable court is there. As I say, since I have made a representation, what is the wrong of disposing my representation? If I'm aggrieved, I'll approach the appropriate forum. But initially, I have approached them, Lordship. So let the authority dispose of my representation. That is only that's my prayer in my petition.
But by not disposing of your representation, whether your fundamental rights are violated.
Because I have stated that because no sort of natural justice was given. So.
Okay, I'll go through
Lordship,
your pleadings. I'm reserving the order.
Give it to Lordship.
Heard Mr. S. Temjen, learned counsel for the petitioner. Also heard Mr. E. Tiba Fom, learned senior government advocate. Hearing concluded, judgment reserved.
Lordship.
Much obliged.
For hearing, item number 61.
Oh, I'm not having.
May I please, Your Lordship? Lordship, I'm making a submission on behalf of my senior, Mr. I.M. Timon, Chair, Counsel for the petitioner. Lordship, let this matter be taken tomorrow.
Not tomorrow, after a week.
I've taken the consent of the government advocate.
Not tomorrow, actually, there are already matters listed. Next week.
Okay.
Heard Miss. Yes, your name is Vikono Kizo, who submits on behalf of our senior IMT launcher and prays for adjournment for a day. She has also submitted that she has obtained the leave of learned counsel for other side. Considering the submissions made by learned counsel, let this matter be fixed next week.
Much obliged.